So, how much time will you take?
2 weeks, I think, because what they have been doing is Supreme Court, the matter is likely to be taken up in the next week. No, because tomorrow is the date before the Supreme Court. So we'll have to take some instruction from the next.
Very well.
So what I would propose with subject to my letter is to say, let it come in the opening day after the issue.
That would be better.
Because in the meantime, what we will do, there are subsequent judgments also which has come of other high courts. So that also we would be taking on it. We have to opt.
So you file within this week,
Month.
and thereafter 2 weeks to them.
Yes.
That will take care of the 3 weeks left.
Yes.
And you, both of you, apprise us tomorrow or day after as to what happened in the Supreme
We
Court.
will do that.
Item 18 to 25, 24.
This 25 also, Ms. Lavanya.
No.
24 Ms. Lavanya Ravati is appearing.
Very well. Then counsel for the respondent income tax department, Mr. Rahul Lamba and Ms. Amrita Sinha, submit that counter affidavit would be filed within this week. Stop. Learn counsel for the petitioners in the respective writ petitions pray for 2 weeks' time to file rejoinder. Stop. As prayed for, list the case in the reopening week after summer vacation 2022. Compilation of judgments and relevant provisions of law, circulars, etc. be submitted before close of summer vacation.
Yes, we will do that.
Very good.
But there are interim orders.
Interim orders dated so and so shall continue till the next date.
Much.
Very well. Please wait. Let us complete our business according to our timing, and then. Routine. You want adjournment for what purpose? So 1 week or 2 weeks. And counsel for the appellant, Mr. P.S. Pati, submits that the matter may be adjourned for 1 week to enable him to submit the written notes of argument and compilation of decisions. Stop. You are. Let's wait for list the case after 1 week. This is only for admission and your purpose. Let us. 1 week. And 11 who was asking?
11 also.
Achha. After 1 week, Mr. Garodia was not well also. 11, and counsel for the petitioner has prayed for an adjournment for which an email was with consent of the other side, for which an email was also circulated yesterday. As prayed for, list the case 1 week. Mr. Pati.
From the date published under the heading for order with effect. Item 1, first appeal number 18 of 2021. Mr. Samedra Varun for the appellant. Mr. Rajit Sinha for the.
Okay.
No, revised it says that only the interlocutory part, interlocutory order part now has removed the high court judges and found the judges of the Supreme Court, 60 law. There is similar provision in the Special Courts Act will be considered. Resolution circular notwithstanding any contained in CRTC or also notwithstanding independent. Supreme Court said that in that case, since it is a non-obstructive clause and it starts like notwithstanding any contained in CRTC, therefore the regular meaning given in interlocutory orders in CRTC of intermediate orders will not apply. Having regard to the object of the act, speedy disposal, and having regard to non-object clause, we have to naturally understand interlocutory that is any order without not a final. And This is problem.
So practically a literal meaning of
Yes,
interlocutor.
literal, natural sense.
Natural sense.
Anything which is not minor is interlocutory and therefore not.
Today, we feel that we can decide your matter. I mean, dictate the order itself.
I think that is this issue of powers in matter. That's all.
So let us first finish the rest of the matters. There are not many left, but you need to keep watching.
Yes. I've given you set of window.
Item number 2, first appeal number 13 of 2022, Mr. Siddharth Rai for the appeal.
Three or 2 weeks.
2 weeks.
2 weeks time. Remove the following surviving defects of the student. You are Mr. Antariksha Narayan, AC to Mr. Siddharth Roy. Very good. But peremptory order, remove it, otherwise it will be dismissed.
For orders, item 3, civil review number 89 of 2018, Mr. Bhaiya B. Sujit Kumar for the petition.
So now you have a report of the Singapore High Commission also. Now you have a report from the Singapore High Commission also that the addressee is not living there. Are you aware of the office note? You go through it.
So, my lord, I have got address.
Now you have got the correct and present address.
Yes, my lord, the address is same, but she has changed her name like Nesa, N-E-S-H-A, Nesa Srivastava. Actually, her name is Nisha Prasad.
So she is residing in Singapore only.
Yes, ma'am. You know, very.
Initially you used to live in Singapore and
Yes,
she used
madam.
to stay in Ranchi. Now you have come back to Ranchi and she has gone to Singapore. As far as I remember, because this has been running since last 4 years. In fact, the previous one was running for quite some time. You go through the office note, after we finish the orders case, then you again inform us as to what is to be done.
Item 5, WPT number 3908 of 2020 along with item number 6. Item 4, civil review number 88 of 2019, Mr. Bitu Kumar for the petitioner, Mr. Sachin Kumar for the petitioner. Item 4,
Yes. IA for substitution. Six has died.
Yes, respondent number 6. Respondent number 6 to the LP number 83 of 2000.
So, Wakalatnama of the legal aid would be filed by the counsel for the other side. You are praying for acceptance of the Wakalatnama?
We have referred this review against the order of the LPA. The LPA was referred by the state.
No, that we understand. But this opposite party number 6 is in the array of opposite parties. So how can the petitioner file a Wakalatnama? Or your counsel of petitioner can file?
This was counsel for the petitioner and counsel for the respondent in the LPA. Now these respondents have referred this civil review before. So they are the petitioners who are now.
No, all that is good. But even if they are pro forma respondents for the time being in any identical situation, petitioners' counsel do not appear for that pro forma. Either they ask to transpose the pro forma respondent as petitioners, or somebody has to appear, or notice is waived. You say that no requirement because they are pro forma.
Now this set of petitions might come to us.
We have understood, Mr. Dev. We have understood. Perhaps you are not understanding the complication. You cannot appear for both the sides, na? That's as simple as that. Whether they are pro forma, whether they were co-petitioners there, now they are on the other side of the fence. So you are for state. Anyone else appearing for the rest of the respondents? Not yet. So why can't you ask the other opposite parties who were your co-petitioners to engage some other counsel, and then the other counsel will file a wakalatnama on behalf of the legal heir of OP number 6 also.
But then this
Substitution at your behest. No difficulty. But appearance on behalf of somebody else.
that has to be, that's one. That is,
These elementary mistakes should not happen. Now you are sufficiently senior.
now what has happened is person was left out because of that. Now what happened, the other petitions were come, they could community below that if something is.
All that you can explain, they can explain, but you cannot vouch for them.
So now let me withdraw this IA application, let it be filed by the.
IA
For
substitution is good so far. But wakalatnama acceptance is so you file a fresh IA, delete the rest portion regarding acceptance of wakalatnama and seek substitution. And in that case, if anyone is appearing for the pro forma parties from the other side, opposite party, they can appear for her also. Hello. Then counsel for the petitioner, Mr. Samaves Dev, seeks permission to withdraw IA number 2960 of 2022 and file a fresh interlocutory application for substitution of the OP number 6 after deleting the unnecessary prayer. So, liberty is granted, IA number so and so is dismissed and withdrawn. Did the matter appear after 2 weeks? Mr. Ravi Prakash Mishra for the AG2, AC2 AG.
Item number 5, WPT number 3908 of 2020, along with item number 6.
In view of the further discussion, the summary of show cause notices, both dated 14/3/2020, adjudication order dated 13/8/2020, and summary of orders, both dated 11/9/2020, issued against the petitioner in both the writ petitions are hereby quashed and set aside. However, the respondents would be at liberty to initiate fresh proceeding in accordance with law if so advised. As a result, both the writ applications are allowed and disposed.
I agree.
Item number 7, WPT number 1429 of 2021, Mr. Sumit Gauri for the petitioner, Mr. Ashok Kumar Yadav for the respondent.
You are feeling good enough to do this case?
That two matters were important. In fact, nothing survives in this matter now in view of the counter filed by the respondents and the order of the assessment which they have passed at an extra age. So, let me see that for a moment. I had claimed migration of the ITV in Jharkhand, and the amount to the extent of my TDS was not allowed to be migrated by saying that it does not, it is only entitled for migration of ITV, and not allowed to migrate the TDS amount. But apart from the legal submissions, it will also see the order of assessment of the year 2017-18, with the respondents are themselves annexed. And the compare is going to start from page 19. Relevant is at page 21.
Yes.
At the bottom of the column which is there, इस प्रकार शासकीय रहित कुल आउटपुट टैक्स की राशि इतना पैसा होगा इनपुट टैक्स क्रेडिट का सामान्य है वर्ष 2016-17 में इनपुट टैक्स ड्रॉप फॉरवर्ड then plus आरुचि अवधि में सीक्वेंस इनपुट टैक्स क्रेडिट 35 लाख प्लस जेवैट 400 स्रोत पर कटौती की गई राशि और दिस इज द टीडीएस अमाउंट 4307,310 exactly the same amount and the total input tax credit is 179,26,192 less. Now they are saying less. GST transfer hetu input tax credit carry forward. So they are the exact amount which I carried forward in GST transfer, which includes 43 lakh 7,000 and odd amount of TDS. They are not giving me the benefit. They are saying that this is already transferred to transfer, and the balance input tax credit is 5,56,000, and they are deducting this only against my output tax liability and asking me to pay the output tax liability of 42 lakhs.
So the main dispute is taken care of.
No, they include order will have to go. But in the assessment order, when they are treating the same amount as TDS as carried forward in GST transfer,
Then the case in which Amrita Sinha is arguing that she is in fact arguing it quite vehemently to carry forward the TDS.
I am also there.
So the issue is common. So if the respondents are taking a stand that they are allowing permission to carry forward the TDS amount also, that takes care of the.
In fact, you will also see the provisions. The provisions are unambiguous. It says credit of value added tax. And TDS which has been deducted is a value added tax. So they can't go beyond the provisions of section 140. What is the precarious situation for the SSE? 2017-18 assessment, if they were in 2022. But if they said, they would have said that we are not entitled for a carry forward of this amount, then immediately I was entitled for refund of that amount. And I would have claimed refund under section 52. So on one hand, you are saying that you are in the original orders which are issued before your auction, they deny the carrying forward.
This is what order? An extra?
An extra is my regular assessment order for the set period.
No, so this assessment order is under the VAT Act.
Yes, and I claim also migration under the VAT Act.
But the GST authorities of the state or the state tax authorities were taking a stand that you are not entitled to carry
Not
forward.
entitled to my entry.
So you are, you have brought this order, Annexure A. Don't you have the copy of yours? Hmm?
We have that.
Annexure A है, and which one is the original one in the writ petition?
Yes, original order is the repetition is that. Is at page 128, DRC 07, they have not even issued the adjudication order.
And 183 Annexure 17,
Yes, 183 is the
appellate order.
Appellate authority.
Appellate order.
In fact, the appellate authority also in this case, the first order which was passed by the respondents themselves, they initially denied my entire claim of ID. Then the respondents thought that no, entire claim cannot be denied, only TDS portion should be denied. So in initial order, if you notice, which are saying at page 128, that is the order by which the entire claim was denied, so I preferred an appeal against that order before the appellate authority. In the meantime, they issued a rectification order saying that no, only the ITC which you are claiming towards TDS is being denied. So, in the first appeal, I filed an application for withdrawal of the appeal, saying that now this appeal has been rendered infructuous, and I filed a second appeal against the rectification order. The appellate authority adjudicates my first appeal, despite noticing that I have asked for a withdrawal, and says that no, you have first confirmed the original demand of the original disallowance. And then in my second appeal, he says that I am nullified for pursuing my second appeal because I have filed two appeals on the same. This is the order passed by the
The first adjudication order, why did it disallow the entire ITC?
So he said that first that I have not annexed the original order, adjudication order. That original adjudication order has not yet been supplied to me, the certified copy. Even before this honorable court, the counter affidavit is not filed. And counter is filed, even that adjudication order is not on record till today.
Same situation as that Godavari.
Yes, Godavari. In this case, they have not even attempted to bring the adjudication order on record.
Imagine Saraswati Godavari. सप्त नदियों का पानी जल. How do you reconcile two stand by the same authorities exercising different jurisdictions? One under the JGST Act and the other under the VAT Act.
Our stand is that they will
It is irreconcilable. No? It is not a reconcilable stand. Either you stick to the stand of that DRC 07 or the appellate order, or you, whatever you have done now and yourself brought it on record, that is for the same period, that
yes, the same period. Yes,
covering the same period. You accept that he has carried forward. आपको नहीं समझ में, are you not ready with your file? आप पढ़ लीजिए फिर. Please make him clear.
I will my written submission also.
नहीं, आपका ही order annexure A जो है ना, that redresses the grievance of the petitioner, क्योंकि उसमें आपने उनका वो GST Tran 1 में TDS को carry forward करने का allow कर दिया है, but in a VAT assessment. How do you reconcile this position? The authorities are the same. One shoe, another shoe. अब देख लीजिए फिर वो गोदावरी की तरह आपका फिर से बड़ा peculiar position नहीं हो जाए.
And in fact, your Lordship's first order, your Lordship specifically noticed and contention that neither the adjudication order, neither the rectification order is supplied to me. And one of the grounds by the appellate authority is that you are not enacting the adjudication order, you are not enacting the rectification order, and your appeal is not maintainable and it is dismissing it on that ground.
In counter also they have not
No,
brought.
they have not enacted, and your order
Then you
specifically.
bring, ask your officers to bring. That is the only way now, because the officers are not supplying you all instructions. In Godavari also we had to call the officers, then the things were clear. Ask the officers to come with the records, complete records. There is an IA for the same.
Specific for that request.
Okay, then counsel for the petitioner has drawn attention of this court to the VAT assessment order dated 22nd March 2021, Annexure A for the period, for the same period, tax period 2017-18, wherein the assessing officer has allowed carry forward of the input tax credit of carry forward the value added tax as ITC through GST Tran 1 to the tune of rupees 1,73,69,826.00, which also includes the tax deducted at source. Stop. He submits that the same tax authorities while exercising the powers under the JGST Act in a different shoe, have denied the carry forward of the TDS of the value added tax for the same period. So, it is further submitted that the adjudication order has still not been brought on record by the respondents through their counter affidavit, in respect of which DRC 07 was issued, imposing the demand of tax, interest and penalty to the tune of rupees 2,21,98,638, and as also confirmed by the Joint Commissioner of Commercial Taxes Appeal, Dhanbad Division, Dhanbad. Also impugned in the writ petition.
Then the rectification order, that demand was itself reduced.
The rectification order reducing the demand after disallowing the carry forward of the TDS amount of VAT has also not been brought on record. Stop. Then counsel for the state, Mr. Ashok Kumar Yadav, GA1. Seeks time. Stop. Let the concerned officer, respondent number 4 and 5.
Yes. The 4 and 5, PDO, the order was filed by the PDO, state tax officer 5.
But he is not a party.
So he is a party number 5.
5.
State tax officer.
4 and 5 appear with the entire records of the case on the next date. List the case on 4th of May. That's a virtual day. I don't know whether.
Wednesday.
Peaceful to have in Jaja and Jaya Janan wala hai. इसमें की वो revenue intelligence. Wait, any exam ninth करो ये बड़ा वो अच्छा हाँ फिफ्थ ऑफ में 5th में हम्म। That IA can be disposed of. No?
Yes, sir, that I.
IA number 1950 of 2021 seeking production of the records of the proceedings is accordingly disposed of.
March number case for orders item 3 civil review number 89 of 2018 Mr. Bhaiya B. Sujit Kumar for the
Yes, have you seen the office?
Yes, sir, I have gone through. But I have got address number and correct name. I.
How do you know that she is the same person who has changed the name?
Yes, sir, my friend has got Facebook account also.
No, Facebook, etc. No. Change of name can be done only through a legal method.
But see, my client has also went to Singapore and he verified from her office. And
You have to file
You
those
have filed your
documents.
documents. How you say that particularly Neha is Nisha? How it is possible?
Nisha is Nesha.
her name is Nisha.
Whatever.
And his name is changed as Nisha.
Your allegation is that she has changed her name. So what is the evidence behind it? Facebook account to खुलता है daily.
Not, I can say that she has not changed her name, but spelling of her name. That I spell is not as such.
The report of
You can understand.
High Commission is there.
You can understand that the court will summon only the person who is the concerned party. There may be thousands of persons with the name of this petitioner, respondent, or the name of Nesha Prasad. We do not know Nesha Srivastava or Nesha. In fact, she is writing, according to you, she is writing Srivastav now or Prasad? So that's a change in name and surname. So how has that, if you want to substantiate that she is the same person, then you have to produce a valid document to show that the change of name has been effected through a legal means, not through Facebook itself.
So, if I do not find any document, I can show an affidavit. If I be some
No.
the
The court is to render a finding and then issue notice on the corrected name. You very well understand the problem before the court. So you देखिए the office has reported that in pursuant to the order dated 10th March 2022, has reported that pursuant to the order dated 14th February 2020, fresh notice was issued to the opposite party under ordinary process as well as registered cover with AD, but unserved service report of notice has been received from the Nazir, and undelivered registered cover with AD has been received with the endorsement addressee left within inverted comma. Stop. Earlier, in compliance to the order dated 16th August 2019, unserved service report of sole OP was received with the report from High Commissioner of India, Singapore, that within inverted comma, no such person at this address. Stop. Then counsel for the petitioner submits that petitioner has obtained certain information as to the whereabouts of the opposite party. Stop. He seeks further time. Stop. It appears that the matter was adjourned repeatedly on previous two occasions. In view of the same office report, but no further steps have been taken by the petitioner for effecting service of opposite party. Stop. Therefore, by way of last indulgence, 3 weeks time is allowed. 4 weeks time. As per 4 weeks. Yes.
For admission, item A, civil review number 53 of 2019, along with item number 9. Mr. Mahesh Tiwari.
There's a notification that the Indian Board was 14th of March 2022. But when only 5 years of the railways have been taken over the office of the Assistant Solicitor General. So they are still taking care of the movement of the 5 years, maybe adjourned for 2 years.
Just by the soft copy of the file can be given us to the soft copy of the file, if it can be saved or mail, just review and something, so that we can apply the office, because in the immediate effect, the earlier panel was put to rest by working to watch notification, and there is some
You get a properly authenticated certified copy of the entire pleadings. We do not know whether the present files have been scanned in the last 2 years for our perusal or consideration.
because same situation we are confronted with in court number 7, where the soft copy just linked to us.
So that file may have a soft copy, scanned copy, and that we do not want to set as a precedent to supply, because you understand there is a lot of exercise going on for scanning of the fresh file records also, which is delaying stamp reporting, etc. We do not want to add this burden. Next day, tomorrow you will say the other one again.
Because most content matters, I just explain the process.
You get a certified copy. No? You charge your client.
I have the notice has been issued that these are internal that going on with the files is not aware of the process. So I don't want to make this on submission. The difficulty is the last 14 March, almost 1 month has elapsed, and with immediate effect, the notification has also been sent to the start. But the hiccups is coming immediately.
Better to get a certified copy of the.
So 4 weeks time.
In fact, you should apply for certified copy in all such matters where you are not. So the State Union of India will pay for it, and they will do whatever steps for the erstwhile council if they are not passing on.
Anyway, I can apply for it. So 4 weeks time is given.
who is for the opposite party? They had taken time to file counter affidavit.
You can take from the opposite party, Xerox copy.
I'll ask my.
Yes, you can take Xerox copy from your learned.
Yes, sir.
Learned ASCI submits that as per the recent rearrangement, the files concerning the railways have also been allotted to the office of ASJI by notification dated 14th March 2022.
The first notification is 1st February 2022, followed by the notification given to the first page balance
First
and
notifications dated 1st February 22 and follow-up notification dated 14th March 22. Stop. However, the files have not yet been transferred to his office. Stop. He seeks 3 weeks more time to obtain the copies of the pleadings from the erstwhile council or by any other means from or through the council of, for the opposite party or by obtaining the certified copies of the pleadings. Respondents council also prays for 2 weeks time, council for opposite party, 2 weeks time in civil review to file counter affidavit in terms of the order dated so and so. Stop. Matter is adjourned for 3 weeks.
Item number 10, WPS number 4654 of 2019, Mr. Sumit Godia for the petitioner, Mr. Ajit Kumar for the respondent.
Then issue better writing is the So in this case, our admitted fact is that the movement of the goods and occasion pursuant to a valid motion. But Rigo is one of the world leaders in transportation of goods, and the goods were transported on behalf of ITC Limited.
Yes.
State Council of Legal Question of This is This is zero. This is zero. This is zero. This I want to do an amendment in this way.
इसको आसान बनने से जमशेदपुर को तो
आसान बनने से जमशेदपुर आना था इसको करना
We'll do it on any other day. Let the name of Mr. Piyush Chitres, AC to AG, appear in the cause list for the respondent henceforth in the place of the previous counsel. Stop. Since Mr. Piyush Chitres has some personal engagement, matter is adjourned for the day, or maybe be available on next Monday also. Adjourned to be listed on
Second,
one May.
second May या fifth May.
Second, 5th May 2020.
The project Supreme Court judgment which is there, the High Court had imposed a cost of 10,000 rupees. Supreme Court has enhanced this to equivalent to the penalty on an appeal by
The expression is very.
Yes, the expression is actually.
Here there are so many cases of such, therefore the state exchequer will be. एक ही गलती हमेशा कर रहे हैं.
Rather necessary to enhance the amount of cost. And realize it as a concern.
Item 12, WPT number 2043 of 2020, along with item number 30, Mr. Sunil Kumar Agarwal for the petitioner, Mr. Amit Kumar, Mr. Ratnesh Kumar for the.
issue in this case is wrongful availment of the input tax, the transitional credit. It is not a case of input tax. Wrongful availment of the transitional credit on the second occasion without utilizing it. And for that reason, that was reverse stored. That has been also recorded in the last one, and since that it has been put in detail. That is the order dated, order number 3, dated 15th February 2021.
Yes. How did the proceeding start?
The proceedings started, what happened? These are some admitted facts which are also there in the council of the government. I'm just submitting for you. In the year after the enactment of this GST regime, after the enactment of this GST, IGST, and JGST Act, in the year 2007, a transitional provision was made. That is specifically in Chapter 20 of the GST enactment. Chapter 20, which deals with transitional provision. Section 140 is one of the provisions, which says that whatever credit one SSC registered dealer in the previous regime, that he can avail and utilize in the GST regime also. So for that purpose, there was a form transfer in accordance with the new regime. Now this petitioner, he had certain credits during the previous regime, so that transitional credit was availed by them. But again, wrongly, the same claim was made by this petitioner. The same.
In filing his GST at 3B.
Yes.
And that could get reversed only in July 2018.
Exactly.
According to them, there was a provision for reversal existing,
Yes.
but petitioners could not invoke that.
Yes, that imposes some argument against so that what they are submitting, that is in fact not the credit situation, because that is in respect of section 42, and our main argument is that section 42 will not apply over there, because section 42 is in case of input tax credit and not in case of transitional credit. There is a separate definition of input tax and input tax credit under section 2.
They do not dispute that you were entitled to carry forward the ITC through transitional credit.
Yes.
They are only initiating, or they have initiated a proceeding because you have twice availed it through GST R3.
But
So that is an ITC. GST R3B is an ITC carry forward.
Yes.
Return.
Transitional credit. And in fact, no proceedings was ever initiated when
when this was 400, this is also admitted that.
That is why we are asking that how did the proceedings start?
When the petitioner reversed it in July 2018, as the Lordship has rightly pointed out. Thereafter, in December, they served us with the notice. November 6/11/2018, an impure notice, and it states at page 40. This is rather not in confidence. Page 40, 204. They read it out.
So this is not a notice in the format prescribed under.
No, it is rather, it is a request of a
information regarding since they have no mode of return of ITC, they are only aware that GST has 3 weeks. And after they have filed in July 2018 the return, then the department came to know that they are only aware this amount twice. One is under section 140 transitional and credit, and one under this GST in the return of July 2017. They should have refunded in the return of August 2017 as per the provision of
All that we also understand. We are asking that you have, when you,
initiation of proceeding under 73 has not.
no, not even 73. If you find a person liable for payment of any tax, interest or penalty, DRC 01A is an intimation to the person. कि आप नहीं दीजिएगा तो आपके खिलाफ प्रोसीडिंग शुरू करेंगे, either under 73 or 74. So this letter is not in the form of any notice prescribed under the Act.
Since they have, as per the council of there is a petitioner that accepted that they had only aware the IDP, so proceeding has not been initiated. Rather under section 53, which is the provision of employment here, they have asked for the interest for the period of 1 year. From July 2017 to the time they have refunded at July 2018.
So point is that the interest is in the nature of a penalty or is it in the nature of a compensation, compensatory tax, compensatory in nature. So in that case, the availment of the ITC through GSTR 3B, how does it affect the revenue for you to ask for interest over that? If the entire amount was kept lying in his electronic credit ledger throughout that period?
They have not utilized that portion of the.
Had they utilized the question of compensation? You have appeared in the other case in which Mr. Kurmi had argued on the interpretation of section 50. A batch. So on the last date, perhaps we have asked the CGST also to give their stand as to how they operated. You are appearing in that case, or Mr. Pati is appearing.
In one case, notice, Mr. Pati,
The final notice does not reference
By this order, we have asked CGST to give their stand.
This is the final order where your office has dealt upon the issue of.
Oh, acha, acha.
Sorry.
Please
Relies upon the Gulabari case and the Bangladesh case.
And there is one matter.
No, I thought this matter was pending. This we have disposed of by remanding the matter.
Yes, yes.
Taking note of the arguments on the leviability of interest. So,
Your Lordship, sir, then, in view of the provisions of section, the moment a person denies either
we remember that.
impose the imposition of penalty or the fund, then they require an ratification in terms of section 20.
No, the point is that have you given any reply to Annexure 6?
And it's still 60. Yes, thereafter we have given a reply, and then that has been rejected. Just thereafter, our correspondence reply is there at this point. That is also Annexure 9, page 67. We have replied to this Annexure 6.
69.
57. Annexure 9, page 57.
57.
This is the reply dated 9th of January 2019. And this refers if you know what is dated 6/11/2018. It is reply to that.
This interest component is not on account of any tax remaining unpaid after the due date. Isn't it? It's only because of the
Wrongful agreement.
undue or excess claim of ITC twice.
They have accepted that they were not doing the provision therefore they have wrongly identified.
So the point is that if it is compensatory in nature and the revenue has not lost anything,
Since their intention is that there is not any right, but they are trying to wrong. It shows that they are not.
That is immediate position also.
that is not disputed that they have not utilized it.
Something that can take the price of counter also it is not very.
No, there is a categorical statement in the counter, para 7.
Also, I statement also understood in the line of the
This shows that they do not dispute the fact that has not been utilized. Para 7, the last sentence.
and you after reply given by the patient also, and it's a 10 has been issued by the patient. Where it has been a request for payment of because the additional 26 lakh rupees were claimed for refund of
That is page 60. Page 60, that is also.
Side don't do side.
That was adjusted against the demand of 72 lakhs of interest. And the rest amount will be demanded.
Which paragraph?
The request for waiver of interest is not acceptable if we are following statutory provision of PSC Act. Section 73. Very conscious to proper officer that any tax has not been paid or short paid or expenses refunded or where income tax credit has gone to the case and imply for any reason other than the reason of fraud and misappropriation of the tax. These are none of the person that it has not been quoted or it has not so short period to be different as a resting in here. Otherwise, only again the reflecting or encourage input tax credit. Regarding to show as to why we should not pay the amount specified in the notice along with interest revenue under section 15 and penalty level under the prescribed rules. On the credential provision of under section 73(1) of the GST Act 2017, it is evident that the wrongly availed input credit is recoverable along with interest and penalty and irrelevant of the fact whether they are wrongly availed input tax credit have been utilized or not. Further, in this defined case, no proposed the provision schedule for recovery excess wrongly availed input tax credit because the same has already been reversed go modo by you before it comes to knowledge of the department. So interest and penalty is also able to recover for the said excess wrong availment of IDC under section 73 months and section 53 of the GST. This is given the section 53 of the 50 clause 3 of GST. Section 52% was made and due excess claim of credit under section 10 of section 42 of undue excess reduction in output tax liability under section 10 of the section 42 shall pay interest on such undue excess claim or on such undue excess reduction as the case may be at such rate not exceeding 24% as may be notified by the government on the provision. There, after they have given a draft of it, the amount is 3 crore 7 lakh 43,055 that has been availed by them on 99,017 and that has been reversed on 38,018. Number of days delayed in being at 28 related to this threshold. Therefore, the total is 57 lakh 18,704. Do you offer your festival pay interest of rupees 27 lakhs 16,704 immediately? So the respect of our interest, rupees 26 lakhs, which has been there, filed for the refund, and has been adjusted. Already been adjusted for the income tax and the
Mr. Amit, you seek instructions or examine yourself, because there is one part that excess claim of ITC has been made. That is an acceptance. But the second part is that it is not actually availed, utilized. Now, from your part, intimation under DRC 01A in the proper format was necessary or not in such a case. It may include tax also, penalty also, or it may include only interest also. कि आपने इस पीरियड में एक्सेस सेक्शन 53 के मुताबिक क्लेम किया, तो you will have to pay interest. The person can pay that and fill up that form B, part B of that DRC 01, or can give, and in the form B it can say that I object to the payment. Then you issue DRC 01 and a summary of show cause notice that your objection is rejected, and why not you be proceeded. Now section 73 of course has its own consequences. So this part which we have been observing in one or two judgments like Mahadev Construction and then and however, the main issue which would go to the root of the matter is if the interest is compensatory in nature, then if the revenue has not lost anything, because it was not due to revenue, tax already paid by him, that is not disputed. Excess ITC carried forward, not due to the revenue, because erroneous carry forward or not against any tax dues that were lying. They were lying idle. So how this compensatory nature of the interest component gets satisfied? And those procedure in the prescribed format. So you be ready on it and give your own short notes also, so that your you need to improve on that. The reference may be made to the order dated 15 February 2021. Readings are complete. However, the twofold question which the counsel for the petitioner has raised, twofold issues which counsel for the petitioner has raised are: one, whether interest under section 15, primarily being compensatory in nature, can be levied upon the petitioner if the ITC has not been availed twice through mistaken filing of GSTR 3B after the same had earlier been carried forward as transitional credit through GSTR Tran 1. And also the same got reversed in July 2018 at the behest of the petitioner. It is the petitioner's case that no tax dues remain unpaid during this period. ये तो नहीं है आपका? Stop.
that is the admitted position.
Question number 3. When counsel for the petitioner submits that despite taking an objection to the notice at annexure, your reply is annexure 9, notice is annexure 6. Despite taking an objection to the notice at annexure 6 dated so and so for payment of interest in terms of section 50 clause 3, subsection 3 of the CGST Act, through reply dated so and so annexure 9 by the petitioner, the procedure prescribed for realization of interest, if any, the respondents have not followed the procedure prescribed for realization of the interest. So, no proceedings, no intimation in the prescribed format or proceedings have been initiated for recovery of the interest part. Stop. Then counsel for the interest in terms of section 50 clause 3 of the Act. The counsel for the respondent seeks time to obtain specific instruction as to whether the ITC of the amount of rupees 3 crore 11 lakhs 43,255 claimed twice by filing GSTR 3B for the month of July 2017 had been utilized by the petitioner before its reversal or not. You would also seek instruction whether for the said tax period there remained any unpaid tax over which interest or penalty could be charged. Apart from the notice for payment of tax in terms of section 50 clause 3 of the Act. Stop. As prayed for, when do you want? Okay. As prayed for by learned counsel for the respondents, that will be listed after 3 weeks. Counsel for the parties would supply the written notes, if decisions, if any, on which they seek to rely.
Bill has been passed recently by the Parliament, and there is a proposed amendment proposed in the CGST Act as far as section 15 is concerned to bring it clearly as to ITC habit and utilization. And then only section 53 will apply. And apart from that, from 24% also it is got to be reduced as 18%. Because 51 says 18%, and this is 24%. And what the second question has been formulated, I think so. The petitioner would have replied that even section 42 will not apply even, because it is not a case of ITC. 42 is only in case of this match, as to whether there is matching between the seller's record and the purchaser's record. So far as the ITC tax credit is concerned. So that would be also in according to the conditions of the petition, but that will also not apply.
Some incidental questions would also arise.
Another question which is out of court of claim as to compensatory nature as to
can propose whether the utilization part that has to be clarified, whether they are not utilized, the residents can be done.
Okay, sure. Let us see. ये आइटम 17 में कोई एडजमेंट नहीं है ना, 17 और 26 25 जरा कॉल कर लीजिए.
Item 17, year number 7 of 2021, Ms. Amrita Sinha for the applicant, Mr. Piyush Pradhan for the respondent.
Yes.
This matter, before going to the question of law, I will just point out certain facts of the matter. This is in the second round of 263 proceeding. 263 proceeding was initiated and was by order dated 28/2019, which is an extra one. Thereafter, the petitioner duly participated in the said proceeding. So cause was issued, they participated, filed and replied. However, no point with respect to jurisdiction was ever raised before the authority. Thereafter, the assessment order was passed. That was passed on 28/12/2019. And after passing of the assessment order, they went before the ITAT straight away against the order of 263. The assessment order was not challenged by them until they did stand as it is, and the ITAT satisfied stating that 263 under section 263 the officer did not have jurisdiction. And the ground of limitation was also not put forth, and the limitation was also not controlled there. It is from the delay on the part of challenging the order dated 28/3/2019, that is passed under section 263. And therefore, you are here before this. The question of law is there at page 17. The second question of law is relevant with this.
So, pursuant to the order under 263, fresh assessment order was passed.
Already passed, and after passing of the assessment order, they went before the ITAT challenging the.
That assessment order is not under challenge in any forum.
In any forum, yes.
How does now the order of ITAT prejudice the revenue?
That assessment, the 263 proceeding by which the entire proceeding was initiated, that 263 has been set aside, and therefore any subsequent order can be stated that it may not be given, or the difficulty is on our part that any subsequent order to that. We are facing that difficulty also because the very initiation was has itself. And it's
That has not been clearly properly stated in the court. What has happened in this case, that in 2016 December, one order of 120, in December 216, the original assessment order was passed. Thereafter, in December 2017, after 1 year, one order of 263 was passed by CIT. And it was the original assessment order, and it has given some directions on some additions and on some modification inquiry was required to be made. Thereafter, after 1 year, in December 18, fresh assessment order is pursuant to that original order of duty passed by the system officer ultimately boundary requirements. That means that the order of you original order passed in December 2016 was not substituted by the new order passed in December 2018, and that order was not in existence. That was in this order. What has happened thereafter? Another CIT came, and he in March 2019, after 3 months of the subsequent order, passed an order in the section 263, order in the section 263 again.
Against? Against which order?
Against the original first order which was passed in December 16.
That was not in existence.
That was not it. That is our main
Then
all
what?
which we have taken before the tribunal.
Thereafter, what happened? Who?
Thereafter, the order was being passed by the assisting officer, and at the fair end, before passing of the order, we have informed the assisting officer that we are going to against the order of 263 before the tribunal. You keep your assessment proceedings in abeyance. But he has said that no, since there is an order in the 263 and limitation is there, I have to pass my order within the limitation period. Then he passed fresh order on 20th December 19. And we have also filed a appeal before tribunal on 20th December 19 along with the limitation petition. Describing the reasons for which there was a delay. That was filed along with the appeal. The department is saying that we have not filed any limitation, that is also not correct. All the facts have now been brought on the record by the department. Thereafter, we have filed an appeal also before the CID appeal against that third order of assessment, which is still pending. So all these are the facts.
So, what we understand from your sequence of facts, that there is one assessment order,
December 16th,
December 16th, then 263 order,
December 17th,
then one fresh reassessment order, December
December
2018.
18th.
In between, there is a second order under 263.
No, after that, after December 18 and March 19.
After that.
After 3 months of the second order.
Okay, so the second reassessment order was valid so far as obedience to the
Yes.
263 order was.
Yes, sir.
Now, the commissioner again passes an order under 263 after December 2018 against the first assessment.
First assessment order, cancelling that order and directing it.
That was not
almost
in
all the issues which were already considered and decided.
And the assessing officer again passes the third assessment.
Third assessment.
And you have gone against which order to the ITA?
Against ITAT, I have come against that division, second division order.
Second 260.
It's a second
And
to
CIT appeal against the third assessment order.
Okay. And you have gone against which order to the ITA?
The last assessment order, third assessment order.
You have,
We have not gone, they have not gone.
Okay, it is there.
They have
Yes.
gone.
In second 263 order, we came before ITAT, and given a decision in our favor, against that they have talking.
Yes, that is.
May I just comment one thing, Lord? In the first round 263, there was only for a limited power that was open, not the entire issue was not covered.
But the power is there. You can investigate anything.
No, Your Honor,
Under 263, once it has
on
been
which
issued.
point it has been directed, only that point can be taken into consideration. The entire, it was not passed to pass the fresh de novo order.
Your Honor,
It was not a de novo
I will
proceeding.
also tell you facts and more facts of that. In the second assessment proceedings, before that in 263 order, the CIT had used the word, the earlier order passed on 28/12 is cancelled, directing the AO to pass this order after examining the issue and discussing the order. And while passing the second order, the AO and issued so-called notice say we have made issued inquiry letters to the various
Another question
parties.
arises, how the second 263 will be maintainable, because you are challenging you are pushing the original assessment order when your erstwhile has already
Yes.
set aside that order.
That
So
is what-
whether it will not be deemed that you are taking over the power of the other CIT who is of your equal range.
In the first,
you see, the second order under 263 directed against the first assessment order was not maintained.
no,
Not maintained.
that
Because,
is,
because the second assessment order had come by that time.
that is a specific case, Your Lordship, that the second assessment order which came, the first 263 proceeding which was there, the relevant court is there at page 60 of my memo of appeal. It says that I therefore cancel the order of the assessment order of the assisting officer passed under section 143(3) of the IT Act for the assessment year 12-13 and direct the AO to pass a fresh order after examining the issue discussed above. So only it was limited to the issue which was there under
Understood.
263. It was
Understood.
not a de novo proceeding.
No, but once, even on a limited issue, the first 263 order directed AO to decide that issue.
Yes, sir.
That led to a second assessment order.
Yes, sir.
The second 263 proceeding, therefore, was totally out of place in respect of an first assessment order because that order was not at all in existence.
But if that order was in existence so far, then only part of the order was.
It means,
Both
The other points.
second 263 goes to show that the first 263 was invalid.
The issue involved in both the issues, and there is a time limit of initial
Why?
263, that
It is
is
a
2 years
public money,
from the
after
end of the
that,
relevant assessment. And within that time period, it was.
How do you say that the first assessment order continued to exist even after passing the second assessment order pursuant to 263
Only for
demand?
the reason, your lordship, my perception is because it was only for the limited purpose 263 was open at that time. Only for a limited issue. There were many issues during the assessment procedure.
Whether the previous 263, my previous commissioner was barred for opening the entire issue. Still, I remember there is one judgment. If there will be 263, the AO will be free to go for entire year. Amitabh Bachchan has said something. It is of 2016 or something.
He has examined, they have not signed the copy of the order. In detail, they come in, we have to discuss duly in the order of the tribunal. The order of tribunal is running in 25 pages, Your Lordship, and they have mentioned in detail all the examinations which have taken place.
You file an affidavit narrating all the facts.
Okay.
Your counsel, respondent seeks and is allowed 2 weeks' time to file counter affidavit containing the complete narration of facts and events with supporting documents / orders. District
I
affidavit.
lost maybe
3 weeks.
You have to very exhaustive on it. ITAP order is of 25 pages.
3 weeks.
Item number 25, first appeal number 11 of 2022, Mr. Sadhu Kumar Naik. Item 25,
Issue notice some ground of adultery. ये उज्जवल कुमार रॉय others क्यों लिखा हुआ है? Others क्यों? Issue notice on the respondent and the marriage has been dissolved. You are aggrieved by that. On the respondent. About this ordinary process, from registered cover, ordinary process and speed post. For which requisites be filed within 1 week. Peremptory. No, that you have already filed. So, filing of appeal itself within limitation. So that we won't stay at. So what? No. your respondent has remarried or?
Item 15, LPA number 7 of 2021.
Just a minute, Mr. Deep, the mentioning of maybe one council from outside this country.
Yes.
Answer case of notebook number 1. Item number 28, LPA number 341 of 2020.
In this case, before I enter into the matter, so we have a limited point as to whether the interim order which was granted in the civil bench on 11th of November 2020 can be restored.
Please wait, let the council first given to the court. Your other side councils are not there today.
I think he was here. I just let him outside before I entered. He was perhaps hoping that it will take a little longer the other matter. He was telling me. And perhaps
The leftover matter is a longish matter, so perhaps it is ready for hearing.
there's no my associate. In the meantime, I just give a broad idea. What's a very different proposition which the Honorable Supreme Court allowed me. I initially wrote and approached the Supreme Court under Article 32. Along with a bunch of matters from the PI. This was not a PI. The Honorable Court said, which is at the page number notes, it's there already. Just before you also go into the let me tell you what exactly the background. I filed an Article 32 questions as an individual, along with a bunch of PI which was going on before the Honorable Supreme Court. And the entire bunch of petitions were asking for a remedy like waiver of interest. They were saying there's a lockdown, the pandemic, and the interest should be paid. They were asking for a benefit under the Disaster Management Act 2005, Section 13, which talks about the relief. That during the pandemic period, the central government authorities are not statutorily empowered to grant extra relief, including the interest and the loan waiver. So therefore, their entire conspectus of the argument before the Supreme Court was a policy statement, saying, we are in a state of distress, please give us that relief. And then they were also asking for extension of the moratorium period, which the RBI granted only for 6 months, beginning from 1st of March 2020 till the 31st of August 2020. So, why this particular judgment, I entered into that through Article 32. At the middle of that matter, on the 5th of September, By that time, these matters were going on for about 4-5 months, 3-4 months. And in the meantime, interim order was passed also by the Supreme Court on 3rd of September. I tendered appearance on the 5th of September. The Honorable Supreme Court, appreciating a kind of a proposition which I gave it, which I coined the term called the black hole doctrine. I'll explain it later. What is called black hole doctrine? I'll explain it later. This is an extremely new proposition of the law, different from the force transfer doctrine. Your Lordship, appreciate one thing. Generally, what happens to avoid the liability under contract, we invoke the doctrine called the force majeure, or doctrine of frustration, or doctrine of proportionality. But we all know what is the jurisprudential principle of the doctrine of force majeure. The force majeure can only postpone the obligation, but it will not absorb the liability during that period of force majeure impediment. While this proposition law is a different.
Just a minute, Mr. Das. Mr. Pati, you are representing Punjab National Bank.
Yes.
This company is a borrower of your bank. The other respondent is RBI, who was noticed but has appeared or not appeared.
There was twofold order. There was the action of notice upon the Reserve Bank of India as well as the Council, Mr. Neeraj.
So, have you effected service on the RBI through Mr. Neeraj Rai or through the usual mode?
Through both. We have also spoken to the London Council, who on the last occasion travelled with me to Delhi. I have already intimated. He also referred back to me by saying that in the meantime, RBI has not authorized for this particular matter. Therefore, he may not appear. But as far as this proceeding is concerned, which is on my limited subject of interim order, which is not against the respond number 2 RBI, but it is against the respond number 3, which is the contesting party as far as the limited purpose of this particular proceeding.
No, the first order which the coordinate bench had passed.
28.
There, at
Yes.
paragraph 14, it was observed that the court, at this stage, without taking affidavit from the respondents, we are not inclined to pass any order in this case.
Correct. Now, we'll also read the paragraph 15.
So,
Accordingly, the respondents shall file an affidavit within 1 week. Why? An order similar to the order dated 11 November 2020, as passed by this court, did not granted in favor of the appellant during the tendency of the LPA, which shall also govern the secured property. So that is why this affidavit was directed and
so who all have filed their affidavits?
You have, I have 5 minutes.
You have opposed the prayer or,
Yes.
and who else is appearing? Union of India, ASJI, you have filed any affidavit? All of them were asked to file an affidavit by that order.
And we answer because we have taken the forceful action, issuing the possession notice, and in fact taking over the forceful physical possession to then for the distribution. That has already been done.
That proceeding is a proceeding under
Securitization, for which the Honorable Single Judge has said that he has a remedy before the hearing. Twofold elements, twofold issues were there. But he had picked up 2 issues. First, he had challenged the RBI circulars and notifications saying that they are not correct because only moratorium has been granted, there should be a total waiver. And in the same rectification, he has also challenged by 32 notice, during pendency, we had also issued the possession notice. So he has filed an IA, making the challenge back possession notice as well. So his challenge were twofold. Number 1, the policy of the Reserve Bank of India, and second, the action under Securitization Act. So far the first plea is concerned, the Honorable Single Judge, taking into note the judgment of the Honorable Supreme Court reported in 2021 volume 8 SEC page 5 of the 11, tells that he does not proper and tenable. Because the Honorable Supreme Court has also held that no, there cannot be a total waiver. What can be there is a moratorium. That for that limited period the interest will not be charged. The judgment squarely covering this issue. Honorable Speaker has mentioned for the Honorable Supreme Court. And so far, the action under Service Act was, it was simply that since there is an alternative remedy, it should avail that. And more so during pendency of the rectification, we had also uploaded the DRC under the RTPI Act, and in that the suit was filed, summons were issued,
present state of property.
Property we have taken over physical possession, forceful physical possession through DM order that has brought the
What kind of interim order do you
Yes.
address for?
The interim order laws which I am stating right now is the status code laws. That is good enough for me. But before that, I must draw the attention to one correction of what my understanding has actually. That exactly is actually misleading. I will understand this at the honorable judge. My case is not about the waiver. My case is absolutely not a waiver. My case is whether I am liable because that performance of paying interest under a loan contract, which is injuncted by operation of the law, can be enforceable under the law. My case is not policy legislation.
No, you went to the Supreme Court for the purpose of seeking a waiver or a deferment of the payment of interest. The rest of the matters before the apex court was for this purpose.
When I came there, the court said on 25th of September, by hearing my petition, the court said that your case is different from other class of bunch of matters before us. And therefore, Article 32 is not to be entertained right now. You go, this is a good proposition of law. You go to the High Court. I have made it a verdict of the High Petition that the court has stated to me that you get it adjudicated because you are given a completely new proposition of law. What I made my claim is a contractual obligation has two components. A loan contractual obligation has two components. One is an interest component, one is a principal component. Interest component is guided by operational performance, which is linked to the period. Now, when the period is injuncted by operation of law, not by act of God, but by operation of law, whether it is at all enforceable under the law.
Which law?
Indian Contract Act, Section 36, Section 56.
So these issues are to be determined by a fact-finding court.
No. This is a purely proposition of law.
No. Whether the contract was frustrated or performance of promise was frustrated by intervening circumstances which you are pleading has to be examined on facts by a fact-finding court.
No. Understand? What is my case? It is independent of facts. It is a new proposition of law. Let me again rephrase myself, but I do not have conveyed my words correctly. A contract, in order to operate, needs a medium of law. Now, the banker expects to enforce the performance obligation of payment of interest under the contract, accrued under the contract between me and it. I say, I am not asking the frustration. I am also not asking a post-result doctrine. I am also not asking for the proportionate doctrine of proportionate provisions. What I am asking is a liability of interest which will accrue and link to the period. Because every day and every second the interest will accrue under the contract. I am under obligation under the contract. That part of my obligation under the contract. Now when a day-wise period is injuncted by operation of law, not by act of God. That's why I say, I am not asking relief under the post-result doctrine, it's a new doctrine. Because never in the history, Lords will see, never in the history, this proposition has ever emerged. Because DNA Act never operated. DNA Act of 2005, by which the legislature authorized the statutory authorities to injunct the period. Now, what is the interplay between the DNA Act and the Indian Contract Act? This interplay is never tested by any court till now. And I say this, my submission is this. When a period is injuncted by operation of law, not by act of God, because my claim is not act of God, and never in the history ever injunction of this nature under the DNA Act or Epidemic Disease Act of 1897 ever operated in a way to claim this nature of proposition of law. And I have presented in this report. I will take you through that written note. Even I have given a written note on this. Let me, not a single judge, question me about whether it is even maintainable. That maintainability was in fact argued by me and brought about the entire set of documents in the form of a supplementary affidavit which is filed for the Supreme Court to demonstrate with a comparative table that what is my nature of relief, what is their nature of relief, and how at paragraph 147 the same honorable court in the Small Scale Industries Development Manufacturing Association judgment 23rd of March 2021 has recorded that there is no legal proposition. In fact, I am the person who argued on 2nd of December. Here are two reasons. I have also annexed that. To the extent saying that my propositions are completely different and nobody is questioning that. Never been questioned. Be that as it may be, on facts, on documents, whatever the Supreme Court is there, I have already annexed A. B. The paragraph by paragraph, the same judgment of the Honorable Supreme Court has stated that there is no legal proposition before us. It is only thing is that few parties expect little more relief from us, which is within the realm of the policy, which is beyond the scope of the judicial review. Somebody wants more relief, somebody wants more moratorium. It is not we as a institution competent to decide a subject which the experts like RBI or the ADMA or the central government are empowered to. And whatever the need they have given in the form of whatever guidelines, we are not going to question. Even though, to the extent up to 2 crore, on the ground of Article 14, the entire SSCs were, entire borrowers were given that kind of relief even in that. While on one hand, they have stated that judicial review has a limited scope, and therefore we cannot go into that. But on the touchstone of the Article 14, saying that it is discrimination because the central government came out with a scheme, October 2020 scheme, by which they granted the interest waiver. The phrase is interest waiver up to 2 crore loan outstanding. But they have lifted that classification up to 2 crore or beyond. And they said that this waiver has to be for that 6 months period or across. That's it. So what my humble submission is that my case, not even yesterday, not even today, is on the ground, and I am going to show this on the board that this is ever attempted on the existing jurisprudence. And that's why I wanted to draw Lordship's kind attention to my petition's affirmative effect. I said so, that this is what the Supreme Court allowed me to present all these petitions and before the Honorable Jharkhand High Court, so that this Honorable Court can have the occasion to test this jurisprudence for the first time. Second, well, this is at case number yes, at page number 80, para 28. At WPC number 1045, page number 80. 80. This is part of the revision. Paragraph number 4.26. That WPC number 4045-2020, which was tentatively issued to listed as was finally listed as 25/9/2020. After a lot of development, this minister under Article 2.2, all players and all persons of law just recognition. We also make and we also turn to that order of the Honorable Supreme Court. number 269.
You appear to have a short compilation of the relevant documents.
Yes, because I have given that. You also will see the next I will also will see extremely concise.
Those are not with us.
Okay, and may I also give you my written note which I have prepared for my lord's and assistants and the written note which I typed for the single right, which is only 2 pages. You will also see how it is distinguished from that. Let your lordships, this is actually page number third movement, lords. Page number 269. I read the paragraph 4.26 at page 80, and now I will show you lordships the order. You always report for the 25th of September 2012. This is the same party lords. Page
Yes. Compilation. Because your brief is bulky, we will spend a lot of time turning around pages and some profound arguments also it seems you have reserved for us. So, it would be convenient if you give a compilation to us, to them also.
Well, can it be in the form of a proceeding state and the
No.
layout?
That the council will rise.
Convenient compilation.
You see,
Your advocate will
the kind of which they are kept there, cover your area.
But I have done little more. To see, I have done the tabular form of online, just quick.
No, whichever form which is convenient to the court.
I would like to give you this one, so extremely helpful. It will give you an entire paragraph of only 1 page, 1 line.
Very well. So you
give that.
you give it to us in hard copy together with the convenience compilation of the relevant documents.
Right. Yes,
So that-
yes. Understood. Yes, better.
So some kind of a spiral paper book kind of thing.
Just for the sake of errors, I'll give you one page. You just see the page number for a moment. You also will find it extremely convenient also. Just for a moment, you also will find it convenient. I will turn to page number 787 to 788. This is only a 2-pager written word which I find about the distinction between this matter and the Supreme Court. A pointedly asserts it has not been touched up. Page number 787 and 788. If this will help about 788. Well, has it with 787?
Yes.
This is actually on the first page, not on the maintenance rating. And if also will see the page number 795 for a moment. 795 to 798. This is on the merit of post-lecture of really how I have remarked my argument with the entire conspectus of my arguments first and broadly covered under 3 baskets.
So we appreciate that, but for your arguments at this appellate stage,
Thank you.
perhaps you would revise some of the
Correct. I'll do it. Thank you. Thank you.
submit it to the court within a day or two. Have a date, whichever is convenient.
In the meantime, we'll also just can you have my regular expenditure 2 paper. Just can you have it?
This one.
Yes, because it's a colored one. And what I have done is that I have given the paragraph of the review document, that's all, and my answer in the most concise form possible. I'm not going to argue on it.
No, we understand, but the convenience compilation is not there.
Correct. And with the annexes, relevant annexer page.
This may be a very precise written notes or a list of dates, but to correlate it with the documents which you,
Right.
that you can prepare. And
I also given the page number. I have also given. But only I request this on for in the meantime. I'll tell you another proposition. The second proposition is a glaringly illegal. That how a bank will exercise the power under 32 on it, if what other than non-payment. This is also not answered at all. Because 32 operates in the teeth of the Article 388.
by which time will you be able to give those convenience?
Yes.
So, suggest a date on which we can keep this matter. In case the regular DB1 is available, then okay, otherwise
Next month.
next 25th. Very good.
In fact, there is no counter argument at all. Neither in the leading by any parties, or it is answered by the
The matter has been mentioned. By the counsel for the appellate, Mr. Sujit Das, from the list of DB1 in view of the urgency shown and the notice dated 3rd March 3rd April 2022, in terms of which urgent matters of DB1 can be mentioned before DB2 stop. It appears that Mr. P.S. Pati, the counsel for the respondent, Punjab National Bank, has filed a counter affidavit.
Well, counter affidavit limited on the point of grant of
A counter affidavit on the limited point of interim relief. Now, it appears that in terms of the order dated 28 March 2022 passed by the coordinate bench, notices have been issued upon respondent number 2, Reserve Bank of India, which has remained unserved. Learned counsel for the appellant submits that learned counsel Mr. V. Pandey Neeraj Rai has informed him that he is not instructed to appear on behalf of the respondent number 2. Therefore, notice need to be effected upon respondent number 2. In terms of the order dated 28 March 2023. Then counsel for the appellant has pressed the prayer for interim relief. However, for the convenience of the court, he undertakes to supply written notes containing the list of dates and a convenience compilation of the relevant documents plus annexures relied upon, including any decisions on which he seeks to place reliance. Stop. As prayed for with the case of 25th April 2022 before the appropriate bench. Stop. Written submission be supplied and convenience compilation be supplied latest by 22nd April 2022.
Was to the limited extent of putting the clock back on 11th of September.
So that we follow.
And what I am now saying, putting the status quo nothing will all this. So that
Not today, next day maybe we or the other bench might be able to appreciate that.
On the division of possible case item number 50, LK number 7 of 2021, along with item number 60.
All private respondents are here.
I see. But without admission. If I have registered something,
Without?
admission. I have brought this notice I have received to the process.
You were the
Contacting
who has got the promotion
yes.
in 2019.
Yes. I have no objection or employment. Just supply with the election. If I was exercising in 18.
The states appeal also have got a copy.
उसका भी पत्र हमको मिला स्टेट का भी वो भी नहीं दिया इसमें भी ये भी नहीं दिया और सब रूल रेगुलेशन सब लगा हुआ
You have been served notice through the departmental head. You have not supplied the complete
ना ये
annexures.
आज जो ऑर्डर में था
ये जगह एक नोटिस हमको मिला है कि कौन सी
ये ना हम लोग आपत्ति नहीं कर रहे जरूर नहीं मिलाऊंगा बट रिकॉर्ड तो फिर से
There was an order not because the original file is distributed. Therefore, let's the action is we have given a convenience compilation.
that will do that
original
NPM that I practice for election 18 हाँ 22 sorry 22 एक कहीं दे दीजिए ऐसे काम करेगा
कंपाइलेशन दे
अरे ऑर्डर में था कि मेमो ऑफ अपील भी सबमिटेड अलोंग विद द रिक्विजिट्स तो इसलिए इन्होंने किया अब यू आर राइट नाउ दैट यू हैव अपीयर्ड सबके बिहाफ में एक कंपाइलेशन दे देंगे ताकि वो उतना सारा प्रिंट नहीं करना पड़े फिर दीजिए फिर अर्जेंट हो जाएगा
Well, my senior says he is not opposing, he is not asking for them.
that would be like with you also
Values, yeah. So,
that's how we let appeal go appeal
then we have nothing to say this. But we are saying.
actually single judge not single judge my appointment was not questioned my lord has not quashed it but it decided on a point that even you are not eligible, but you are senior, then you will be permitted. This is the case in a sense. Clearly, it should be criteria. This is what I say. Identity coming.
Yes. You will supply the
देखिए
entire.
ऐसा कर सकते किया जा सकता है मिस्टर अजीत कुमार सुधार उनके you give me the copy to the I will if I will take for that also. Or any student gets used to your class.
As per your lordship convenience. But however, the issues are very, very much in. From both the sides, judgments have come. Because we have given written notes also. So that today again I have given. Issue lies in a very narrow point. Whether seniority come merit will accept my contentions or whether seniority come merit has been properly dealt with by the honorable. That's rightly recall 2019 there had been a transaction promotion grant 2 years there. That time they have not questioned. And
You are appearing for the interveners.
for the rate petitioners.
We,
They are for the rate petitioners. Interveners are.
we took time to understand the party position. With great effort on the previous days while issuing notice. Now again,
Rightly pointed out that the issue controversy hinges within a very narrow compass. Lord, the promotion has been given to the private respondents who will
so you are for the interveners.
Yes.
You have got the promotion.
And the intervener.
No, Mr. Rajiv Kumar Sinha's client has got the promotion.
2019.
They wanted promotion on similar lines like Mr. Sinha's client.
No. Because we were in the pipeline, we became entitled in February 2020 and we could have been promoted on the same ground on which Mr. Sinha's clients have been promoted. They were not eligible then, they are not even eligible today. They say that the rule concerned on the 2014 notification is bad because it gives a relaxation to the seniors who have completed 20 years. They say we have been promoted in the just previous rank earlier by the limited examination, so we will rank. Issue is right. They were not eligible. They
जो सर्किट डिस्ट्रैक्ट है नन गस्टेड पोस्ट है सीओ या सेटलमेंट ऑफ द गस्टेड पोस्ट हाउ कैन सिनर्जी कैन बी क्रेडिटेड ओनली
Lord, that is what the question is to be decided by the court.
yes
That is what will be the statement of the circular regarding relaxation given in the condition for promotion of the eligibility criteria. This is what the core issue.
It would be much easier if any one of you plays the case of all the parties.
Yes, I am ready to do that. I am ready to do that.
Because the same fact should be repeated by all of
I am
you.
ready to do
So facts undisputed be placed by any one of you.
Yes, yes.
So that we can easily reach to the root
Yes.
of the matter.
but I will assist you now in law point of law let my fact my friend is more
मतलब हम सब जजमेंट उनका भी अपना भी what is their contention, what is our contention, what judgment they trying to apply for, everything I can place. क्योंकि इसमें स्टेटस को ऑर्डर था इस वजह से थोड़ा सा
contesting private respondents in the writ petition. Slash respondents here on notice. He submits a copy of the annexures may be supplied. Then counsel for the appellants may be directed to supply a copy of the enclosures as the notice contained only the memo of the appellant. So then counsel for the appellants, Mr. Ajit Kumar, senior advocate, and Ms. Vandana Singh undertake to supply by tomorrow, by day after tomorrow. So, as spread forth by the counsel for the parties, raised the case on 2nd May 2020. When
तो 30 मिनट के देना खत्म हो गया
तो उस दिन फिर देखेंगे। आज तो आप ही का केस था बचा हुआ।
Well, just to save the time of this honorable court, I submit to that as my friend rightly said, that the entire controversy is only with regard to the interpretation of the circular which has been issued by the state of Jharkhand, granting relaxation in the service period for the next promotion. So, as my friend said about that he will lead the undisputed facts of all the parties, and his friend has come to say that he will prepare all yes, notice of undisputed facts. In exchange, it come out by 26th of May, so that if anything addition to that, you may suggest to our friend, and it will save the time of this one.
Very right. You can do so.
Fine. And
After the case, for orders with effect, item number 1, first appeal number 18 of 2021. Mr. Samit.
Tell Mr. Sinha to come. Today you have given only the citation of that judgment or some notes revised?
I've given a letter. I revise this part for revise. What I've done is I've indicated that single judgment of this honorable court on the issue of a section.
Where from is the change in
Page 23 not only relevant that in change.
yes. Yes.
Respect Act 534, I extracted section 11 of the Special Force Act.
Yes.
Notwithstanding anything contained in anything in the code, An appeal shall lie as a right from any judgment, sentence, and order not Section 4 of the Supreme Court goes on facts only. For homology will also take Section 19 of the Act. Family
19 of the
Code.
same language.
Yes, more or less. That's why I just wanted to take note of it. Not only that,
Section 19.
yes.
Yes.
Same as provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure 1908 or in the Code of Criminal Procedure 1973 or in any other law, an appeal shall lie from every judgment or order not being an interlocutory order of a family court to the High Court of Facts. What is important is this notwithstanding. Now here what is CRPC, here is CPC, CRPC ordinary. Now in PC Shukla, what was the challenge before the Supreme Court was an order framing charge. Order framing charge under CRPC was consistently held to be an intermediate order and then revisable in terms of 397(2). So when the matter in the Supreme Court took that event, an objection was raised by the solicitor that it did not retain it. It was referred to a court judge. And the petitioner was appellant's content, no, it is revisable in terms of 397. Therefore, hence appeal will rights and intermediate order. The Supreme Court said no. There was a fine argument made that since it is overriding, there is non-obstacle clause, and therefore it excludes the applicability of CRPC. The interpretation given to 397(2) by various judges does not apply. And since the scheme of the Act was also quick disposal of cases, the intent, legislative intent, was to avoid any appeal because that will be silly precise. Now, I have therefore
This actually removes all confusion about
yes,
import of any other judgment vis-a-vis any other law.
absolutely, absolutely. So therefore, I think that this will answer everything. I have extracted relevant portions at page 24 and 25. It also only 3 pages are extracted relevant portions of issue. Clear.
Yes.
Page 24, paragraph 36.
Yes.
There is yet another aspect of the matter which has to be considered so far as the decision is concerned, to which we shall refer when we deal with the last line of the argument of the General Counsel for the Act. Suffice it to say that the moment that the case referred to fully endorses the view taken by the federal court and the English decisions, is that an order is not final but interlocutory one if it does not determine or decide the rights of parties once for all. Thus, on the consideration of the authorities mentioned above, the following proposition emerge that an order which does not determine the rights of the parties but only one aspect of the scope of trial is an interlocutory order. So the concept of interlocutory order has to be explained in contradiction to the final order. In other words, if an order is not a final order, it would be an interlocutory order. That one of the tests generally accepted by the English courts and the federal court is to see if the order is decided in one way, which may terminate the proceedings. But if it is decided another way, then the proceedings will continue. Because in our opinion, the term interlocutory order in the criminal procedure code has been used in a much wider sense so as to include even intermediate and quasi final orders. That an order passed by the special court discharging the accused would undoubtedly be final order in as much as it finally decides the rights of the parties, but puts an end to the controversy and thereby terminates the entire proceedings before the court so that nothing is left to be done by the court there. That even if the act does not permit an appeal against the interlocutory order, the accused is not get interlocutory remedy because in suitable cases the accused can always move this court in its jurisdiction under Article 136 of the Constitution, even against an order taking charges against the accused. Thus, it cannot be said that by not allowing an appeal against the order, an order taking charges the act was serious injustice here. Applying these tests to the order in June, we find that the order claiming charge is purely an interlocutory order, as it does not terminate the proceeding, but the trial goes on until it terminates in a particular condition. It is true that if special court would have refused to claim charges and discharge the accused, the proceedings would have terminated, but that is only one side of the picture. The other side of the picture is that if the special court refused to discharge the accused and claim charges against him, then the order would be interrupted because the trial would still be alive. Mr. Mittal has referred the argument of the Solicitor General and explained the decisions referred to above on the ground that the English decisions and also the Federal Court's decision make the observations by interpreting the provisions of the Government of India Act or the provisions of the Constitution where the word final order was expressly used. It was urged that that same construction would not apply to the present case where the word order is not qualified by the word final. With due respect to the Learned Council, in our opinion, the distinction sought to be drawn is a distinction without any difference. This court, as also the Federal Court, have clearly pointed out that so far as the test to be applied to determine whether an order is final or interlocutory applies as much to civil cases as to criminal cases. Furthermore, as already indicated, it is impossible to spell out the concept of interlocutory order unless it is understood in contradistinction to or in contrast with the final order. This was held in a number of cases referred to, including Madhuri, which has been expressly stressed by us in an earlier part of the judgment. For these reasons, therefore, the contention of the Learned Counsel for the appellant on this aspect of the matter fails and therefore is overruled. The Learned Counsel for the appellant has finally submitted that the present statute which gives right of appeal should be liberally construed in favor of the accused who has not deprived him of the right of appeal. The Council relied upon the observations of Crawford, the construction of statutes which may be extracted thus appeals. Moreover, statutes pertaining to the right of appeal should be given liberal construction in favor of the right, since they are immediate. Accordingly, the right will not be restricted or denied unless such construction is unavoidable. There can be no dispute regarding the correctness of the proposition mentioned in the statement extracted above. But here, as the right of the appeal is expressly excluded by providing that no appeal shall lie against an interlocutory order, it is not possible for us to stress the language of the section to give a right of appeal when such right has been conferred. Even the statement extracted above clearly says the right will not be restricted unless the construction is unavoidable. In the instant case, in view of the non-obstantive clause, section 11(1) of the Act cannot be construed to contain a right to appeal given against an interlocutory order, and therefore the present clause falls within the last part of the statement of Crawford extracted out. Thus, this argument of the Learned Counsel is also wholly divided of any substance. On a true construction of section 11(1) of the Act and taking into consideration the natural meaning of the external interlocutory order, there can be no doubt that the order claiming charge against the appellant under the Act was merely an interlocutory order, which neither terminated the proceeding nor finally decided the rights of the parties. According to the test laid down in the Swami case, the order included was undoubtedly an interlocutory order. Taking into consideration therefore the natural meaning of interlocutory order and applying the non-obstantive clause, the position is that the provisions of Code of Criminal Procedure are expressly excluded by the non-obstantive clause, and therefore section 397 of the Code cannot be called into aid in order to hold that the order included is not an interlocutory. As the decisions of this Court in the case of Madhuri versus State of Maharashtra and Amarnath versus State of Haryana were given in respect to the provisions of the Code, particularly 397(2), they were correctly decided and would have no application to the interpretation of section 11(1) of the Act, which expressly excludes the provisions of the Code of Criminal Procedure by virtue of the non-obstantive clause. We feel that one reason why no appeal was provided against an interlocutory order like claiming of charge as construed by us so far the Act is concerned may have been that it would be against the dignity and decorum of a very high status which the special judge under the Act enjoyed in trying the case against an accused. in that judge is in that the judge is a sitting judge of the High Court and therefore must be presumed to name charges are only after considering the various principles and guidelines laid down by the other courts. And this court in some of the cases that work. Thus, the summing of the entire position, the inescapable conclusion that we reach is that giving the expression of the law is natural meaning according to the tests laid down, as discussed above, particularly in Koku Swami case, and applying the non-obstantive clause, we are satisfied that so far as the expression interlocutory of the appearing in section 11.1 of the Act is concerned, it has been used in its natural sense and not in special or omitted sense as used by the court. A view taken by us appears to be in complete consonance with the award object of the Act to provide the most expeditious trial and quick dispatch of the case tried by the special court, which appears to be the paramount intention in passing the Act. In these circumstances, we therefore hold that the order passed by the special judge was an interlocutory order, and the appeal filed against the order in this case court is clearly not intended. We therefore oppose the remedy of judicial I think that this covers the entire aspect of the matter. Both that the intention was taken into consideration, expeditious disposal, and interlocutory in its natural sense, not CRS. We are all getting into it. I was personally getting mixed by the interpretation of the intermediate orders being a part of interlocutory orders, not being part of interlocutory. But this case clearly a full judgment and 3-1 majority. That area has to be matched. Because we can use the same word in two different statutes in two different contexts. The context is different. So if I could not appear last year, but I saw it on YouTube or explain. Why do we interpret the Family Courts Act in expansive manner? The term interlocutory has to be understood in narrower and natural sense. After this clause, I have now recently also not into another judgment, 2022 has come Shyam 7000 Limited, where the Supreme Court, by reading the Shah Babuji line, said that not every order is appealable to the division bench unless it has trappings of a finality. Therefore, what happened in Calcutta High Court says, single judge has only granted time to file reply to the injunction. That was questioned in appeal before a division bench. The division bench entertained the appeal, and Supreme Court said no. This was not an order which could have been appealed. And from that was trappings of finality. Thereafter, I have gone to the US cases which are recorded in paragraphs 41 to 45, 43.
Like in the previous.
And it was there in the previous one also. Which also says that in the United States, various states maintain speculative right is something which is order is not appealed. Now, the objection, the stand reporters have said that a revision will lie in this case. A revision will also not lie. That is also wrong objection 227 which will lie. But unfortunately, none of the cases, Allahabad, Patna, Orissa, whatever view they have taken, they are considered decision. And therefore, Rachna Pandya has said that it is against decision directly now. I thought you were for it, and not.
No, but we will use that term. That will enable us to decide it independently.
Yes, yes. That is for it because this was not noticed. This issue was not noticed.
Mrs. Shukla or both the lines of the judgment?
Both judgments are not noticed. There is no, in fact, there is no discussion. This is Uttarakhand High Court and that's all. The short order I have already quoted that.
Yes.
Case 3.
Yes.
I have quoted that. And the very outset, the term of the respondent has been joined issue with regard to intermediate in the line upon the judgment with Rajasthan, like in the case of Mahesh Bhatwar versus Sunita Bhatwar, reported in 95, Rajasthan concept. This is also not concept for the considered by South 9%. And this has relied upon a division bench judgment of Uttarakhand High Court in the case titled Rahul Samrat Kannan versus Srimati Niku Kannan, reported in Soames. There is the same objection raised after passing of an order on the Senate. That is the eligibility of degree was turned down, relying upon the full bench judgment of Allahabad High Court in Srimati K. Balakrishnan. In view of their opinion. So there is no discussion on the contrary. Because I know your options are seen. I have emphasized on Rajnish versus Neha because now that also is important because now it is only an objective assessment of the parties' ability to pay. It does not require scrutiny facts and in law. And therefore, more the reason that the intention can't be reopen it. It will only be substituting one skill on the objective assessment liability.
Whether maintenance penalty act and litigation cost awarded under Section 24 of the Hindu Marriage Act 1955 during pendency of the matrimonial suit would fall in the nature of interlocutory order or intermediate order, and whether an appeal would lie therefrom is the question required to be answered in the instant appeal. Stop. An objection has also been raised by the registry of this court regarding the maintainability of an appeal under Section 19(1) of the Family Courts Act 1954 (FCA) for short, against an order passed under Section 24 of the HMA. Stop. This appeal has been filed under Section 19(1) of the Family Courts Act 1984, impugning the orders passed under Section 24 of the HMA. Stop. The appellant husband seeks to challenge the order dated 3rd October 2020, passed by learned Additional Principal Judge, Additional Family Court, Jamshedpur, in the original suit number 194 of 2018, by which the appellant husband has been ordered to pay a sum of rupees 3,000 per month as interim maintenance and rupees 2,000 as the litigation cost, and in addition to the above, a sum of rupees 500 per day when the wife/respondent appears before the court in person, or rupees 200 on such date when she does not appear in person or appears through video conferencing. Stop. We have considering the seminal issue to be decided at hand and the line of decision on each side of the fence rendered by different high courts, including the present court, including this court, we have sought assistance from the counsel, Mr. Indrajit Sinha, who has been appointed as amicus curiae. Stop. We have heard learned counsel for the appellant, Mr. Ashutosh Anand.
I'm not in this. I was in
Acha, acha. We have heard learned counsel for the appellant, Mr. Sumitro Baroi, also. Stop. Whether since the appeal is at the threshold of maintainability, respondents were not noticed. Respondent was not noticed. Stop. At the outset, it would be pertinent to note that a coordinate bench of this court, in the case of Rachana Pandey versus Sanjeev Singh, FA number 567 of 2014, within bracket, reported in 2015, SCC online Jharkhand 2267, bracket close, had by orders dated 18th May 2015 rejected a similar objection and held an appeal to be maintainable under section 19(1) of the FCA against an order passed under section 24 of the HMA. Stop. The opinion of the apex court, opinion of the learned coordinate bench is extracted herein below. Stop. Therefore, we are faced with the moot question as to whether the order dated 18th May 2015 passed by the coordinate bench of this court in the case of Rachana Pandey's Supra can be reconsidered by this division bench without referring to a larger bench. Stop. Learned amicus curiae has during course of the submission fairly submitted that an order of a previous division bench would be binding on a coordinate bench. However, only if it decides a question of law or lays down any principle of law Stop. The only thing binding upon the subsequent ordinate bench is the principle on which the case has been decided. Stop. Within the bracket, C so and so 2003 7 SCC 197. In the case of so and so 1992 1 SCC 489, it has been held within inverted comma in italics. A decision is available as a precedent only if it decides a question of law. The observations of the apex court in the case of so and so 2005 8 SCC 534 at para 112 have also been placed before us, which inter alia observed as follows, within inverted comma. The trend of judicial opinion is that stare decisis is not a dogmatic rule allergic to logic and reason alone. It is a flexible principle of law operating in the province of precedence, providing room to collaborate with the demands of change in times dictated by social needs, state policy and judicial consents. Inverted comma close. Stop. Learned counsel for the learned amicus curiae has also drawn the attention of this court to the views of the Honorable High Courts, which can be divided into two broad categories. Viz, an appeal is maintainable and the contrary view that the appeal is not maintainable. Stop. The High Courts which have taken the view in favor of an appeal being maintainable under section 19(1) of the FCA from an order passed under section 24 HMA are as under. Page 9 says, para 7 judgments. Stop. The judgments and order passed by some High Courts which have taken the contrary view, that is, an appeal is not maintainable against an order passed under section 24 HMA, are as under. Para 8, page 10. Stop. The rival judgments on opposite side of the fence as to the maintainability of an appeal have time and again raised this legal conundrum before this court also to effectively and authoritatively pronounce upon the question of maintainability of an appeal under section 19(1) of the FCA against an order passed under section 24 of the HMA. Stop. We find from perusal of the order passed in the case of Rachana Pandey, Supra. We find from perusal of the judgment passed in the case of Rachna Pandey that it has relied upon the full bench judgment of Allahabad High Court in the case of Srimati Kiran Bala Srivastav versus Jayaprakash Srivastav. And the judgment of the Uttarakhand High Court in the case of Rahul Samrat Tandon. Following it, wherein the appeal was held to be maintainable. Stop. On the other hand, the learned division bench, coordinate bench of this court has relied upon a judgment of Rajasthan High Court in the case of Mahesh Bharadwaj, where the contrary point of view has been held. Has taken note of the judgment of the Rajasthan High Court in the case of Mahesh Bharadwaj, where the appeal has been held to be not maintainable. Stop. However, the learned court has not taken into consideration the full bench judgment of the Odisha High Court in the case of Swarna Prabha Tripathi and others, wherein the appeal was held to be not maintainable. Stop. As such, we can take note of that the learned division bench, the rival judgment of co-equal benches, that is of Srimati Kiran Bala Srivastav rendered by Allahabad High Court and that of Mahesh Bharadwaj, Swarna Prabha Tripathi and others, Swarna Prabha Tripathi rendered by the full bench of Odisha High Court were not placed for consideration. Stop. The learned coordinate bench of this court, therefore, was precluded from authoritatively deciding the question of law regarding the maintainability of an appeal under section 19(1) of the FCA against an order passed under section 24 of the HMA. Stop. The judgment of the coordinate bench of this court can therefore be said to be per incurium, which enables us to decide the issue to decide the legal issue, the question of law authoritatively with the benefit of the contrary judgments, contrary decisions on this point from various jurisdictional high courts, which has been ably placed before us by the learned amicus curiae. Stop. Para. We have taken note. In order to appreciate the controversy at hand, it is proper to quote Section 24 of the Hindu Marriage Act, HMA, and Section 19 of the FCA. Hereunder, quote, we have taken note of the divergent views of different high courts above. Stop. As would appear from perusal of one or the other judgment, the views of the high courts are founded on two leading judgments both by full bench of the respective high courts, that is Allahabad High Court and the Odisha High Court. In the case of Kiran Bala Srivastav, Supra, and Swarn Prabhat Tripathi, Supra. Stop. It would thus be appropriate to discuss the ratio decidendi of the above two full bench decisions. In the case of Kiran Bala Srivastav, Supra, a division bench of the Allahabad High Court made a reference to a full bench on account of the divergence of views of division benches of the said High Court regarding the maintainability of appeal under Section 19 of FCA from an order passed under Section 24 of the HMA. The judgment in the case of Avdesh Narayan Srivastav versus Archana Srivastav, 1998, LCD 66, which held that an appeal was maintainable, was found to be in conflict with two subsequent division bench decisions in Srimati Pratima Sen Gupta versus Sajal Sen Gupta, 1998, 16 LCD 66, and Ravi Sharan Prasad alias Kishore versus Srimati Rasmi Sinha, AIR 2001, Allahabad 227, whereby it was held that an appeal was not maintainable. Stop. The full bench, after noticing the relevant statutory provisions and considering the definitions of the term decree within quote, comma, judgment within inverted comma, order within inverted comma, and placing heavy reliance on the celebrated judgment of the Honorable Supreme Court in the case of Shah Babu Lal Khilji versus Jayaben D. Kania and another, 1981, 4 SCC 8, observed that an order or interlocutory orders possessing the characteristics and trappings of finality or affecting valuable rights of the parties or deciding important aspects of the trial in the main or in the ancillary proceedings will be a judgment within inverted commas. The full bench also took into note the decisions of the apex court rendered in the case of Amarnath versus State of Haryana, 1977, 4 SCC 137, and Madhu Limia versus State of Maharashtra, 1977, 4 SCC 551, to discuss the meaning of interlocutory order within inverted commas. The full bench was of the view that Section 24 of HMA is gender neutral, but in practice the provision is invoked by the wife and is important from the point of view of the wife, as not only her survival during the pendency of the proceedings, but her right to prosecute or defend the proceedings also depends on the outcome of the proceedings under Section 24. Stop. It further went on to observe that refusal of maintenance under Section 24 is serious to the wife, so much so that she may even give up the idea of defending herself for want of sufficient means. The argument that an appeal against such an order will delay the disposal of the main petition was not accepted by rejecting the contention to give the limited meaning to the word judgment within inverted comma. Stop. It appears that the full bench of the Allahabad High Court did not take notice of the full bench decision of the Odisha High Court rendered in the case of Swarn Prabhat Tripathi and others Supra. Though the earlier decisions of Sunil Hansraj Gupta versus Payal Sunil Gupta, AIR 1991, Bombay 423, and Mahesh Bharadwaj versus Srimati Smita Bharadwaj, AIR 1995, Rajasthan, page 47, were taken note of. Stop. The conclusion arrived at by the Allahabad High Court in the case of Kiran Bala Srivastav at paragraph 28 to 30 of the Manupatra report is quoted here. Page 12. Stop. We now advert to the full bench decision of the Odisha High Court in the case of Swarn Prabhat Tripathi and others, Supra. Stop. In the said case, the Honorable Full Bench was called upon to decide the correctness of a division bench judgment of the Odisha High Court passed in Civil Appeal number 17 of 1996, decided on 8th October 1996 within bracket, comma, which held an appeal to be maintainable. अभी से रिकॉर्डिंग शुरू हो रहा है इसके पहले वाला correctness of a division bench judgment of the Odisha High Court decided on 8th October 96, which held an appeal to be maintainable against an order passed under Section 24 of the HMA. Stop. The full bench, after noticing the divergent views taken by various high courts, focused its attention on the issue as to whether an order passed under Section 24 of the HMA is an interlocutory order or not. And after taking note of the judgment of the Supreme Court rendered in the case of so-and-so AIR 1967, Supreme Court 799, and more particularly in the case of Ramesh Chandra Kaushal versus Meena Kaushal, 1978, 4 SCC 70, held that an order passed under Section 24 of the HMA is an interlocutory order, and as such, no appeal would lie in terms of Section 19(1) of the Family Courts Act. Rather, such order should be amenable to Article 227 of the Constitution of India. Stop. The operative part of the judgment of Swarn Prabhat Tripathi and others, Supra, is quoted hereunder. Is 13. 16th. We may further take note of the full bench decision of the Patna High Court in the case of Neelam Kumari Sinha versus Prashant Kumar, reported in AIR 2010 Patna 184 within bracket FB, which followed the view of the Odisha High Court in the case of Swarn Prabhat Tripathi and others, and held that an appeal is not maintainable. It appears that the full bench judgment of Allahabad High Court delivered in the case of Kiran Bala Srivastav, Supra, was not brought to the notice of the Patna High Court. Rather, the division bench of the Allahabad High Court in the case of Ravi Sharan Prasad alias Kishore versus Srimati Rasmi Sinha, AIR 2001, Allahabad 227, was cited and followed, which stood overruled by full bench in Kiran Bala Srivastav Supra. Stop. Likewise, the division bench of the Chhattisgarh High Court in the case of Anil Mishra versus Sakshi Mishra, AIR 2017 CHH 108, did not notice and consider the full bench decision of the Allahabad High Court in the case of Kiran Bala Srivastav Supra and chose to follow the full bench decisions of Odisha and Patna High Courts. Stop. A subsequent judgment of the Chhattisgarh High Court in the case of Monika Sahu versus Puran Lal Sarwa, within bracket, Manu/CG/1012/2019, bracket close. Though notice the judgment of the full bench of the Allahabad High Court in the case of Kiran Bala Srivastav Supra, but did not assign any reason whatsoever to disagree with it, rather chose to follow the earlier division bench of the Chhattisgarh High Court in the case of Anil Mishra Supra. Stop. An analysis of the two judgments of the full bench of the Allahabad and Odisha High Court indicates that while the full bench of Allahabad High Court in the case of Kiran Bala Srivastav Supra and the decisions of the High Courts following it have approached the issue from the angle that an order passed under Section 24 HMA is a judgment within inverted comma, and have referred to and relied upon the decision of the Honorable Supreme Court rendered in the case of Shah Babu Lal Khimji Supra. Whereas the full bench of the Odisha High Court in the case of Swarna Prabhat Tripathi and others Supra and the judgments and orders of the High Courts following it have placed reliance on the decision of the Supreme Court in the case of Ramesh Chandra Kaushal versus Mrs. Veena Kaushal, 1978 4 SCC 70. Stop. We may therefore proceed to deal with the ratio of the two judgments of the apex court in some detail to understand their applicability in the context of the issue at hand. Stop. In the case of Shah Babulal Khimji Supra, the Supreme Court of India was deciding a substantial question of law relating to the scope, ambit, and meaning of the word judgment within inverted comma, appearing in clause 15 of the letters patent of the Bombay High Court and the corresponding clauses in the letters patent of other high courts, and as to when an interlocutory order will be covered by the term judgment within inverted comma under the letters patent so as to make them appealable. Stop. In Shah Babulal Khimji Supra, the apex court decided as to what kind of interlocutory orders within inverted comma can be considered as judgment inverted comma within the meaning of letters patent so as to maintain an appeal thereagainst to the division bench of the concerned High Court. Stop. Learned amicus curiae has submitted that the said decision is on a different proposition of law and does not and cannot specifically apply specifically to the question raised in this appeal. Stop. So far FSA is concerned, even an order not being an interlocutory order has been made appealable, and hence not at all necessary that an order, it is not at all necessary that an order to be appealable has to be a judgment within inverted comma or brought within the ambit of word judgment inverted comma. Stop. It may be pertinent to note that the letters patent does not define the word judgment within inverted comma, and hence the Supreme Court and various high courts have taken the pain to define the same on case-to-case basis, and after administering the test propounded by Shah Babulal Khimji Supra. Stop. We now advert to the judgment of the apex court in the case of Ramesh Chandra Kaushal Supra, relied upon by the full bench of the Allahabad High Court, Odisha High Court. Stop. The apex court was considering an appeal questioning an order of maintenance granted under section 125 CRPC on two grounds. Is A, that in a divorce proceeding, the civil court had passed an order of interim maintenance quantified at rupees 400 within bracket, which was affirmed by the High Court, bracket close, and hence the determination of quantum by civil court should prevail over a live decision of a criminal court, comma. And B, the awardable maximum under section 125 CRPC was at that time rupees 500, whereas the criminal court's order directed payment of maintenance of rupees 1000 to the wife and her two children as affirmed by the High Court, which was not correct. On both counts, the appeal was dismissed. Stop. While considering the first issue, the apex court observed that the general principle of civil court's order prevailing over a criminal court was inapplicable, as the direction by the civil court is not a final determination under the Hindu Adoption and Maintenance Act, but an order pendenti lite under section 24 of the Hindu Marriage Act to pay the expenses of the proceedings and monthly expenses during the proceedings. So, para 6 of the Supreme Court cases report is reproduced here and there. Stop. Page 18. In respect of the second issue concerning section 125 CRPC, which also deals with maintenance of a wife and minor children, the Supreme Court at para 9 of the report held as under. Page 19. Stop. It has been submitted by learned amicus curiae that though section 24 is gender neutral, but the provision is mostly invoked by and for the benefit of wife in a matrimonial proceeding, and hence the observations mutatis mutandis apply to section 24 HMA as well, and can be applied to find out an answer to the issue at hand. Well, the analysis of the two judgments of the Honorable Supreme Court in Shah Babulal Khilji and Ramesh Chandra Kaushal therefore, yes, switch over. Learned amicus curiae has submitted that in order to interpret the provision under section 19(1) relating to appeal, it is necessary to examine the object and purpose of the FCA. Stop. It is tried that while construing a provision relating to appeal / jurisdiction of the courts / tribunal, the object of the statute can be an aid of construction of the said provision. Stop. In this regard, the amicus curiae has placed the decision of a division bench of this court, within bracket one of this court, of which one of us, Apresh Kumar Singh, was a member, bracket close, in the case of Baga Tirki versus Pinky Linda, first appeal number 124 of 2018. Stop. This court, after taking note of the object and scheme and object of the FCA and the decisions of the apex court in the case of so and so 2003 4 SCC 166 and in the case of so and so 2016 13 SCC 308 held as under page 27, para 9, 11, 12, 13. The amicus curiae has, however, pointed out that an expansive interpretation to the jurisdiction clause of FCA does not ipso facto mean that the appellate provision also has to be liberally and expansively construed. Stop. The appellate provisions have to be interpreted in a manner which would further the object of the statute and not run contrary to the legislative intent. In this regard, he has taken aid of the doctrine of purposive construction, which is a well-settled principle of interpretation, now being progressively relied upon, increasingly relied upon by the courts. Stop. It is submitted that the courts are entitled to look into the object and purpose of the enactment, and in this regard, one may refer to the decision of the Supreme Court of India in the case of New India Assurance so and so 2020 5 SCC 757 paragraph 20 and 21, and in the case of so and so 2021 SCC online Supreme Court 897. Stop. In New India Assurance Company Limited Supra, the apex court took note of the object of the Consumer Protection Act 1986 to interpret the provisions of Section 13 of the Consumer Protection Act 1986. Stop. It took note that CPA was enacted to provide speedy disposal of consumer disputes and, hence, preferred an interpretation which was in tune of such object. Stop. It accordingly held that the district forums had no power to extend the time to file response to a complaint beyond the period of 15 days in addition to 30 days as envisaged under section 13 of the CPA. Consumer Protection Act 86 लिखे उसी में ब्रैकेट में पहले कर दीजिए, hereinafter referred to as CPA. Stop. Likewise, in Municipal Corporation of Greater Mumbai, Supra, the Supreme Court observed that the National Green Tribunal is a forum created specifically to address environmental concerns and was expected to move with expediency. Stop. It went on to hold that the NGT has the power to initiate a suo motu proceedings. According to learned amicus curiae, section 19 of the FCA therefore has to be interpreted in a manner which is in consonance with the object of FCA and section 24 HMA and does not run contrary thereto. Stop. Hence, it has to be ascertained as to whether by holding that an appeal is maintainable, the object of speedy redressal is in any manner being frustrated or not. Stop. the Hindu Marriage Act,
So far as 24 is concerned, the Hindu Marriage Act says it must be 60 days. Therefore, we thought it's this kind of.
it is pertinent to mention that to take note of the aims and objects of the Family Courts Act 1984
The last allotment is considered 21 capital B. This is about 6 months.
of the FCA, which reads as in Family Court Act I first it reads on as code.
Please write.
Stop. It is further pertinent to take note of section 21.
Capital B. Subclause 2.
Modified Adoption of Code Section 21 capital B is complete. The appeal also has priority.
They should be planned.
That is what I will say.
Yes, the answer.
It is pertinent to quote section 21 capital B of the Hindu Marriage Act 1955, also hereunder, which provides for a time limit for conclusion of trials, which provides that every petition under the HMA shall be tried as expeditiously as possible, and endeavor shall be made to conclude the trial within 6 months from the date of service of notice of the petition on the respondent. Stop. It also stipulates that every appeal should, under the Act, should be heard as expeditiously as possible, and endeavor shall be made to conclude the hearing within 3 months from the date of service of notice of appeal on the respondent. Stop. Section 21B is quoted here. Stop. We may also quote section 24 of the HMA, which the proviso whereof also stipulates that an application for payment of expenses of the proceedings and such monthly sum during the proceedings shall, as far as possible, be disposed of within 60 days from the date of service of notice on the wife or the husband, as the case may be. Stop. The aims and objects of the FCA, read together with the relevant provisions of the HMA, both indicate that both go to show that the object of both the enactments are to ensure speedy adjudication of matrimonial disputes or claims relating to, and also claims relating to maintenance, pendentialite, and cost of proceedings. Stop. From a plain reading of section 19 of FCA, it is clear that no appeal lies thereunder against an interlocutory order. Stop. Therefore, to answer the issue at hand, one must pose the following question, semicolon, whether an order passed under section 24 of the HMA is an interlocutory order with an inverted comma or not. What are interlocutory orders? The principles of statutory interpretation provide that even ordinarily the meaning of a word is not to be taken in abstract, but regard must be had to the setting in which the word occurs, as also to the subject matter and object of the enactment. However, in case of doubt, these factors gain prominence in selecting the true meaning out of the rival interpretations which may be reasonably open. See, within bracket, Principles of Statutory Interpretation, 13th edition, 2012, Justice G.P. Singh, Chapter 2, page 124. Stop. The same expression used in two different enactments in similar context may have different meanings, having regard to the object of each enactment. Stop. The expression interlocutory order has also been used in section 397 within bracket 2 of the Code of Criminal Procedure 1974 and section 11 of the Special Courts Act 1979. Stop. In the former, it has been understood in the strict sense, but in the latter, in a wider sense, having regard to the object of speedy trial. Stop. The apex court, in the case of V.C. Shukla versus State through CBI, had the occasion to interpret the term within bracket, within inverted comma.
Citation number
1980 supplementary SCC 92. Had the occasion to interpret the term within inverted comma, interlocutory order, in reference to section 11(1) of the Special Courts Act 1979. For our better understanding, we intend to quote both section 19 and section 11(1) and 2, section 19 of the FCA and section 11(1) and 2 here under one after the other. Section 19 उसका पूरा quote कर दीजिएगा, Family Courts Act, उसके बाद फिर लिखिएगा special. Stop. In the case of V.C. Shukla, the appeal was directed against an order framing charge by a special judge under the Special Courts Act 1979. Stop. The apex court refrained from interpreting the term interlocutory order within inverted comma in a special or wider sense as used by section 397 within bracket 2 of the code of the CRPC and preferred to interpret the term in its natural sense, and therefore by a majority of 3:1 held that an appeal was not maintainable. Stop. The apex court considered the scheme of the Special Courts Act 1979 as a special case which had the object of expeditious trial and quick dispatch of cases. Stop. The apex court referred to Amarnath versus State of Haryana 1977 4 SCC 137 and Madhulimiya versus State of Maharashtra 1977 4 SCC 551 and the non-obstante clause in section 11 of the Special Courts Act 1979. and held that the judgments in the said cases were given in the context of the code, particularly section 397 within bracket 2, and were correctly decided, but would have no application to the interpretation of section 11(1) of the Special Courts Act, which expressly excludes the code. Stop. The relevant extracts of the relevant extract of the opinion of the apex court in the case of B.C. Shukla are the relevant opinion of the apex court in the case of B.C. Shukla are as follows. Paragraph 34, 35, 42, 43, 45, to page 24 से लेकर के 26 के एंड तक के कोई बात सेक्रेटरी को बताइए स्टॉप in view of the above proposition of law, the amicus curiae has submitted that the opinion of the apex court in V.C. Shukla should apply with equal force to section 19 of the FCA. Stop. Section 19 FCA is also has a non-obstante provision within bracket in italics में, notwithstanding anything contained in the Code of Civil Procedure 1908 within bracket 505 up to 1908 bracket 2, or in the Code of Criminal Procedure 1973 within bracket के अंदर वाला bracket 2 of 1974 bracket close, or in any other law बड़ा bracket close, and thereby expressly excludes the CPC and the CRPC in term the term interlocutory order within inverted comma must be construed in its natural sense and having regard to the purpose and object of the act, comma, which necessitates that the expression interlocutory order within inverted comma be interpreted in a wider sense so as to bring within its fold all such orders which are not final. Stop. The concept of intermediate order within inverted comma or a case decided within inverted comma which are revisable under the provisions of CRPC and CPC cannot be invoked in respect of section 19 of the FCA. Stop. Therefore, reference to various case laws rendered in the context of CRPC, CPC or any other law would not be appropriate as it would be unnecessary and out of context. Stop. Amicus curiae has also addressed the issue from a different angle, that is, whether an order passed under section 24 HMA affects any substantial right and has the trappings of finality. Stop. Relying upon the case of so-and-so 2022 SCC online Supreme Court 313 paragraph 17-20, the apex court it is submitted that in the said case the apex court has held that an order passed by a single judge in a suit postponing the hearing of a temporary injunction matter was not appealable. Stop. It was held that an order vitally affecting a valuable right of the defendants will undoubtedly be treated as a judgment within single inverted comma, within the meaning of letters patent so as to be appealable to a larger bench, and an order to be construed as a judgment, comma, within inverted comma, it must have the traits and trappings of finality. Stop. It was further held that each and every order passed by the court during course of the trial, though may cause some inconvenience to one of the parties or to some extent, comma, prejudice to one of the parties, cannot be treated as a judgment within inverted comma. Stop. It would be pertinent to We may now advert to a recent path-breaking decision rendered by the apex court in the case of Rajneesh versus Neha and another 2021 2 SCC 324, wherein for the first time the apex court held that the party claiming the maintenance should be required to file concise application for interim maintenance with limited pleadings, along with an affidavit of disclosure of assets and liabilities before the court concerned as a mandatory requirement. It was further held that on the basis of the pleadings filed by both the parties and the affidavits of disclosure, the court would be in a position to make an objective assessment of the approximate amount to be awarded towards maintenance at the interim stage. The Honorable Supreme Court prescribed the formats in which the affidavits of assets and liabilities were to be filed. A separate format was provided for non-agrarian deponents and agrarian deponents, and also for the state of Meghalaya. The primary reason for providing for the above procedure appears to be that the apex court was cognizant of the fact that despite the time frame provided for by the statutes in the form of the proviso to section 24 of the HMA, within brackets 60 days from the date of service of notice, bracket close, and the third proviso to section 125 CRPC, within bracket 60 days from the date of service of notice, bracket close, the applications for grant of interim maintenance remained pending for several years. The court further noticed that at present the issues related to interim maintenance are decided on the basis of pleadings, with some amount of guesswork or rough estimation, so as to make a prima facie assessment of the amount to be awarded. Such practices, according to the apex court, made it difficult for family courts to make an objective assessment for grant of interim maintenance. The apex court was of the view that that maintenance-taking wife has a tendency to exaggerate her needs, while it is a corresponding tendency by the husband to conceal his actual income, and therefore it has become necessary to lay down a procedure to streamline the proceedings. Since a dependent wife who has no other sources of income, has to take recourse to borrowings from her parents/relatives during the interregnum to sustain herself and her minor children till she begins receiving interim maintenance, the apex court therefore laid down the procedure and guidelines for deciding a claim of maintenance in a matrimonial proceeding or in a proceeding under section 125 of the CRPC. Para 72 of the judgment is profitably quoted here under. Page 6, 7. At paragraph 77 of the judgment, it was observed that the objective of granting interim/permanent alimony is to ensure that the dependent spouse is not reduced to destitution or vagrancy on account of the failure of the marriage, and not as a punishment to the other spouse. Therefore, no straitjacket formula for fixing the quantum of maintenance to be awarded can be laid down. From a cumulative reading of the guidelines and observations of the Supreme Court of India, it is clear that an application for grant of interim maintenance has to be decided in an expeditious manner and to facilitate the early disposal of cases only. The new guidelines were issued. Stop. The nature of a proceeding for grant of interim maintenance certainly is summary in nature. And after the judgment of the apex court in Rajneesh Supra, there is no doubt that the family courts have to decide the matters objectively based on the disclosures made by the parties on affidavit. Stop. Since the interpretation of a provision relating to appeals is under consideration before this court, it would also be proper to delve on this issue at this stage. An appeal is a right of entering in a superior court and invoking its aid and interposition to redress an error of the court below. See AG versus HJ Silem, 1864 within bracket 11 ER 1200, page 1209 within bracket HL within bracket Lord Westbury, L.C. bracket close. Referred to in Dayavanti versus Inderjeet, AIR 1966, Supreme Court 1423, para 10. Stop. In the case of so and so, 2009, volume 10, SCC 531, page 232, at page 532 or para 532.
Page 531.
Page 531, the Supreme Court held that appeal is not a natural or inherent right and cannot be assumed to exist unless provided by a statute. Stop. In Competition Commission of India versus Steel Authority of India Limited, 2010, 10 SCC 744, para 45 and 48, the apex court, while dealing with section 53A of the Competition Act, by which the Competition Appellate Tribunal has been established and which provides for appeals against orders passed by the Competition Commission against any direction issued, decision made or order passed by the Commission under subsection 2 and 6 of section 26, but not against any direction under subsection 1 of section 26 to the Director General to investigate a case when it finds a prima facie case, it was held that no right of appeal can be impliedly inferred. Stop. It is tried that the right of appeal is a statutory right and it can be circumscribed by the conditions of the statutes granting it. See within bracket 2008 4 SCC 720 para 23 to 25. Stop. It is also equally well settled that where the statute does not place any limitation and restriction to the scope and width of the appeal, it shall be construed that the appeal will provide the right of rehearing on law as well as on facts. Stop. There is no dispute that an appeal is a creature of statute and a litigant does not have an inherent right to prefer an appeal in respect of any order under a statute. Stop. These principles ought to be kept in mind in order to answer the issue at hand. Stop. We have quoted the provisions of section 19 FCA in the foregoing paragraphs. Stop. Section 19(1) provides forum of appeal against every judgment or order passed by a family court except when the appeal is directed against the following: small 1, an interlocutory order, semicolon, or small 2, from a decree or order passed with the consent of the parties, semicolon, or small 3, from an order passed under chapter 9 of the Code of Criminal Procedure 1973. Stop. It is explicit that an interlocutory order stands specifically excluded from the category of judgment or order appealable under section 19 of the FCA. Stop. We have in the foregoing paragraphs, we have profusely discussed the rival opinions of different high courts on the question of maintainability of such an appeal under section 19(1) of the FCA against an order passed under section 24 of the HMA. Stop. The question at hand has also attracted the attention of the superior courts of different jurisdictions, other jurisdictions, which we may also briefly touch upon to have the benefit of their valuable opinion. Stop. The Supreme Court of Nevada in your Supreme Court judgments, there are 41, 42,
Yes.
43. 41, 42, 43 can be extracted.
Yes, that, there was some mistake that corrected.
Para 41, 42 and 43 at pages 27 to 20 and 30. तक उसको copy कर दीजिए. Stop. The above authorities unequivocally indicate that an order which does not affect the substantial rights of parties and does not have the traits and trappings of finality have to be treated as an interlocutory order. Stop. We have profusely, we have in the body of our judgment profusely referred to the aims and objects of the FCA, and the provisions of and the appeal provisions under section 19(1) therein, in the context of the provisions of the HMA also quoted herein above. Stop. We also have the benefit of analyzing the line of reasoning rendered by different high courts on the question of maintainability of such an appeal. Stop. While the decisions of different high courts following the full bench judgment of the Allahabad High Court in the case of Kiran Bala Srivastav have taken a view that an appeal against an order under section 24 of the HMA would be maintainable under section 19(1) of the FCA. The other line of decisions have followed the full bench. The other line of decisions have followed the full bench judgment of the Odisha High Court, wherein in the case of Swarna Prabhat Tripathi, यूपी इलाहाबाद हाई कोर्ट का फुल बेंच किरण बाला श्रीवास्तव शुक्ला और उड़ीसा हाई कोर्ट स्वर्ण प्रभात त्रिपाठी have held that the appeal is not maintainable. We have also gone into the reasonings as to why the contrary points of view have been held by the rival set of decisions. Stop. We also have we have also gone through the decision of the apex court relied upon by both the full benches of Allahabad High Court and the Odisha High Court to hold either way on the maintainability of an appeal under section 19(1) of the FCA against an order passed under section 24 of the HMA. Stop. We find that the expression interlocutory order as interpreted in the case of VC Sukla takes into consideration not only the scheme and object of the Special Courts Act 1979, which had the objective of expeditious trial and quick dispatch of cases, but also the view that the cases, the judgments rendered by the apex court in the case of Amarnath Supra and Madhu Linear Supra on interpretation of the expression interlocutory order within inverted comma used in section 397 within bracket 2 of the Code of Criminal Procedure would have no application to interpretation of section 11(1) of the Special Courts Act, which expressly excluded the code. Stop. The wordings of section 19(1) of the FCA are much nearer and in fact more limiting when compared to section 11(1) and 2 of the Special Court Act 1979. Section 19(1) of the FCA as a matter of fact, excludes starts with has a non-obstante clause which excludes anything contained in the Code of Civil Procedure 1908 or in the Code of Criminal Procedure 1973 or in any other law, while providing for a forum of appeal against every judgment or order, not being an interlocutory order within inverted comma of a family court to the High Court, both on facts and on law. Stop. Therefore, it can be safely said that the decisions rendered in context of provisions under the Code of Civil Procedure or the Code of Criminal Procedure 1973 or in any other law would not be applicable while interpreting the provisions of section 19(1) of the FCA, given the scheme and object of the FCA and the HMA both for expeditious disposal of matrimonial disputes. The decision of the foreign jurisdictions also unequivocally indicate that an order which does not affect the substantial rights of parties and does not have the traits and trappings of finality have to be treated as an interlocutory order. So, in the case of B.C. Sukla, the apex court at para 34 of the report quoted above culled out the proposition which emerged upon review of the decisions rendered by the federal court and the English courts, that an order is not a final order but an interlocutory order if it does not determine the decide the rights of parties once for all. An order which does not determine the right of the parties but only one aspect of the suit or the trial is an interlocutory order. Stop. The concept of interlocutory order has to be explained in contradistinction to a final order. Stop. In other words, if an order is not a final order, it would be an interlocutory order. One of the tests generated by the English courts and the federal court is to see that if the order is decided in one way, it may terminate the proceedings, but if it decided in another way, then the proceedings would continue. Such an opinion in respect of interlocutory order in the CRPC could be used in a much wider sense so as to include even intermediate or quasi-final orders. The apex court also observed that even if the Special Courts Act does not permit an appeal against an interlocutory order, the accused is not left without any remedy because in suitable cases the accused can always move this court, the apex court, in its Article 136 jurisdiction under Article 136 of the Constitution, even against an order framing charges against the accused. It therefore could not be said that not allowing an appeal against an order framing charges would work serious injustice to the accused. Similar opinion can be rendered in the context of the expression while interpreting the expression interlocutory order under section 19(1) of the FCA. Stop. If a forum of appeal is denied to a party under section 19(1) of the FCA, it is not that he is left without any remedy. Stop. The aggrieved party can approach this court under Article 226 of the Constitution of India. 227 of the Constitution. Stop. It cannot be gainsaid that considering the pendency of cases and appeals in particular, whether on the criminal side or on the civil side in various high courts, an appeal against an order under section 24 of the HMA would take an indefinite length of time to be finally decided. Stop. Such an appeal would mean a decision by the appellate court both on facts and in law. Stop. A situation may arise if, for example, where a spouse who has got the benefit of an order of maintenance pendency light in her favor would have to wait even after the final disposal of the matrimonial suit itself. On the outcome of the appeal preferred by the aggrieved spouse/husband against such an order granting maintenance pendency light and cost of proceedings. Stop. The whole aim and purpose of the FCA and the HMA for expeditious disposal of the matrimonial proceedings and also the petition relating to maintenance pendency light and cost of proceedings would get indefinitely delayed, thus amounting to causing disservice to the cause of justice. Stop. In view of the judgment rendered by the apex court in the case of Rajneesh versus Neha, now the family courts are obliged to decide petitions for interim maintenance in a summary nature, objectively based on the disclosure made by the parties on affidavit. Stop. An appellate court, if finally, while finally adjudicating an appeal against such an order may ultimately substitute its views to that of the family court, rendered on objective factors based on the disclosure made by the parties on affidavit. This lengthy, long drawn proceedings before the appellate court would render the whole aim and object of the FCA and the HMA otiose and frustrated. Stop. As we have taken note of the decisions rendered by the apex court on the principles of purposive construction for interpretation of while interpreting a statute. The courts are entitled to look into the object and purpose of the enactment. The provisions relating to grant of maintenance, penalty light and litigation expenses are founded on principles akin to Article 39A of the Constitution of India and the right to access to justice, and hence must receive the importance attached to the rights flowing therefrom. Stop. The provisions of Section 19(1) of the FCA therefore cannot be interpreted in a narrow manner. Rather, the interpretation has to be done in a purposive manner, keeping into mind the object and purpose of the enactment for speedy disposal of matrimonial disputes and proceedings relating to maintenance. Stop. Applying the above tests to the order passed under Section 24 of the HMA, it can be safely inferred that an order granting or refusing to grant maintenance penalty light to a spouse does not have any effect on the substantial right of the aggrieved party, nor does have the traits and trappings of finality. Stop. In fact, an order under Section 24 of the HMA does not have any effect on the final decision of the list sought to be decided by the family court. Stop. Having regard to the aims and object and purpose of the FCA, that is speedy settlement of matrimonial disputes, which is also reflected in the proviso to Section 24 of the HMA, Section 19 of the FCA must receive an interpretation which furthers the above intent of the legislation. Stop. Therefore, providing for an appeal or interpreting that an appeal is maintainable against an order passed under Section 24 of the HMA would frustrate the purpose for which it was enacted and might unnecessarily delay the main proceedings before the family court. Stop. Grant or refusal of maintenance pendentilite can at best be an order which causes inconvenience to some extent to the aggrieved party, but in no way causes any serious prejudice to the aggrieved party. Stop. The HMA or the FCA does not provide for any consequences for non-compliance of an order under Section 24 HMA on the merit of the main matter, except that it can be enforced in accordance with law. Stop. Para. The order on an application for grant of interim maintenance certainly is an order which does not in any manner crystallize the rights of any party. Stop. It is a temporary arrangement. Stop. Pronouncement of the final judgment and decree terminates the operation of the order granting the interim maintenance. Stop. The life of an order granting interim maintenance is still the pendency of the proceedings, just like any other interim or interlocutory order. Stop. As observed here in above, in the judgment of the apex court in the case of Rajneesh Supra, in view of the judgment of the apex court in the case of Rajneesh Supra, it cannot be said that the family court, while deciding an application for interim maintenance, has to arrive at a subjective satisfaction regarding the matter. Rather, now the order is based on an objective assessment, and hence the scope of the High Court to interfere with such an order is limited. Stop. The High Court is not required to re-evaluate the entire matter, and an order granting or refusing to grant interim maintenance is not to be tested by an appellate court either on law or facts or both. It can be reviewed by the superior court on jurisdictional issues or perversity, which can be done under Article 227 of the Constitution of India. An expansive interpretation of Section 19 of the FCA, by which it is held that an appeal has been provided against an order granting/refusing to grant interim maintenance, will defeat the object of the Act, that is, speedy disposal of disputes. The appellate court would be under a duty to reappraise the pleadings and the affidavit and return an independent finding which would reopen the issue again and in all probabilities delay the entire exercise. Stop. Such an interpretation runs contrary to the object of the FCA and Section 24 of the HMA and thus needs to be avoided. Stop. The right of an appeal has been circumscribed by Section 19 FCA expressly prohibiting an appeal from an interlocutory order. And the said term interlocutory order within inverted comma has to be construed widely and in its natural sense so as to be in conformity with the object and purpose of the FCA. Stop. We are not oblivious or unmindful of the legal position that the provisions relating to jurisdiction of the family courts must receive liberal and expansive interpretation. But at the same time, the provisions relating to appeal must not be interpreted in a manner which would run contrary to the scheme of the enactment, more so in view of the fact that the provisions of Section 19 FCA has put restrictions on the scope of appeal against certain orders, including interlocutory orders, and expressly excludes the applicability of CPC, CRPC, and all other laws. Stop. Thus, the provision requires to be interpreted by using the principles of harmonious construction, and by applying the same, it can safely be deduced that an order on an application for grant of interim maintenance being an interlocutory order is not appealable. Stop. In view of what has been held here and above, we are of the held here and above. In our opinion, the decision of the this court in the case of Rachna Pandey versus Sanjeev Singh cannot be said to be a good law. With due respect, cannot be said to be a good law, especially after the decision of the apex court in the case of Rajneesh versus Neha Supra. We accordingly hold and declare that an order passed by a family court under section 24 HMA being an interlocutory order is not amenable to appellate jurisdiction of this court under section 19 of the FMA. Stop. Hence, the present appeal is held to be not maintainable. Before parting, we record our deep appreciation for the valuable assistance rendered by the learned amicus curiae Mr. Indrajit Sinha in rendering our opinion on such an important question of law, which has continued to bother the courts from time to time and has led to two completely opposite opinions by different high courts of this country. Stop. We also record our appreciation for the valuable assistance rendered by learned counsel for the learned advocate